Me, please, my lord.
Yes.
Lordship, item number 22, last item hearing.
Yes.
We have filed affidavit, counter affidavit this morning. And also, the opposite party also have filed this morning, it seems. So let the matter come up on Thursday or tomorrow or Thursday.
Thursday,
Thursday.
alternate counsels for the parties. It is submitted that pleadings have been exchanged only this morning. Accordingly, to list the matter on Thursday. Thursday will be. Yes.
Obliged.
May it please the Lordship. Lordship, I'd like to mention item number 18, Lordship. Let this matter be come up tomorrow, Lordship.
Pass over for the day on the prayer of the Lord's Council.
Obliged, Lordship.
Respondent, both parties
Consultations.
on the parties, on the prayer of the parties.
Obliged, Your
Obliged.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention hearing item 12 and 13, Lordship.
12 and
Lordship, here the arguing concern Mr. Ajo is currently out of station for his medical review. I pray Lordship may kindly list this matter after 2 weeks.
Petitioner, yes. Any objection? Oh, okay, okay. And petitioner in WP 192. You're in 29, isn't it? 29 of 23.
Lordship, I'm sorry, 10 and 11. 10, 11, Lordship.
Oh, 10, 11.
Lordship, Lordship.
Okay.
Respondents,
Okay, well,
item 10. Then, when do you want?
10, 11, Lordship.
No, when do you want?
After 2 weeks, Lordship.
After 2 weeks. Item 10 and 11, list the matter after 2 weeks on the prayer of learned counsel for such and such, who has submitted on behalf of of the leading counsel, Mr. Azo, that he has gone for a medical review. So, list after 2 weeks.
There are two cost lists, Lordship. In my cost list, item 10 and then
Item 10 is WP 32 of 25. And item
Yes.
11 is 98 of 23. Oh, item 11, how can it be? Because item 10 is for
IA.
orders, item 11 is hearing.
Yes, Lordship.
No, it cannot be item 11. Something is wrong.
Lordship, they are different.
Yes,
course
yes.
based, Lordship.
You make a mission from
It
here.
appears so.
Your Lordship, 12 and 13, as per the.
So in 12, the petitioner is different counsel. That's why I'm asking.
Lordship.
Yes, 2 weeks. Okay. 2 weeks.
Lord-
So now
Lordship-
finally it's 12.
Lordship, a date may be fixed, Lordship, on 16.
Koza, can you just turn this calendar? Calendar. Just turn it this side and bring it there. Let's see.
On 16, my lord.
Okay, 16th. 16th June. No. 12 and 13, okay. Finally. Yes.
Much obliged, Lordship. Your Lordship, similar prayer for item number 14, hearing item 14, Lordship.
It's also AZO.
Lordship,
Yes,
Lordship.
14 also AZO. Same day.
Lordship, after 2 weeks, Lordship.
You just say after 2 weeks.
Lordship.
No, please, my lordship.
Yes.
I pray to mention item number 7.
Item 7. Contempt.
Yes, the matter is under consideration, so I pray that this matter may be listed after 3 weeks.
Consideration means for compliance.
Yes, yes.
Alternate counsel, B. Shukri, appearing on behalf of the respondents. So she has prayed for how much time?
3 weeks.
3 weeks time. In order to comply with the direction of the court, of this court. Prayer law, please of the 3 weeks.
Okay, much.
please, your lady. Item 15.
Yes.
Your Ladyship, may I pray this matter be passed over for the day? I'm making a mention on behalf of Kiangami. He has some personal difficulty today.
Okay, item 14, pass over for the day on the prayer of the Learning Government Council.
Item 15, Your Lordship.
Oh, item 15.
Yes,
Item 15.
oblige your lady.
My please, Your Lordship. Your Lordship, I beg to mention item number 5, arbitration, petition 1 of 24. My lord, I've received a direction from the respondent number 1. So if 1 week time may be given to me for accommodation, my lord.
What have you received? You have received what?
I don't know.
Has received the instruction, Lordship.
Instruction.
Yes, my lord. I've received instruction.
Please, after 1 week,
Uh,
the prayer of learned council.
Apologies, Lordship. Lordship, in meantime, if as a matter of abandoned question, allow us to implement the Chief Secretary as a party, Lordship.
Chief Secretary, Government of Nagaland.
Yes,
You
Lordship.
file an IA for that?
Yes, Lordship,
Yes.
yes.
After 1 week, no, on the prayer of the learned CGC. That you don't need permission, you file an IA, will pass necessary order.
Lordship. Much
Obliged.
obliged, Lordship.
May I please, Your Lordship. Lordship, I beg to mention item number 4. Lordship, kindly grant us 3 weeks time to file affidavit in reply.
Counsel for the petitioners, research and such, praise for how much?
3 weeks time, Your
3
Lordship.
weeks time to file an affidavit in reply to the counter affidavit filed by the state respondents. Prayer is allowed, list the matter after 3 weeks.
Lordship, I'm appearing here for respondent number 9 and 10.
They are praying for time to file reply.
Lordship.
Lordship, there is an
Learned
interim.
counsel such and such interest is present for respondent number 9 and
9 and 10. Lordship.
10. The interim order passed earlier shall continue till the next date.
Develop, Lordship.
Bless you, Lordship.
Lordship, I beg to mention item number 20 and 21. On behalf of KS Group, kindly this matter may be come up after 3 weeks.
Learned counsel such and such, mentioning on behalf of the council, Kate Sukru has prayed for how much time?
3 weeks.
3 weeks time. CGC, the respondents are not present, list the matter after 3 weeks,
Obliged.
20 and 21. Okay.
May I please, Your Lordship? Your Lordship, I beg to mention item number 16 of the hearing. From the hearing is.
Okay,
Your
MSC,
Lordship. Yes, Your Lordship. Your Lordship, let the matter be listed on 23rd of June.
the prayer of the learned counsel for the appellant, list the matter on
23rd.
23rd June. Learned counsel, for the respondent has no objection.
Lordship, I'd like to mention item number 17, similar prayer, Lordship.
Same day,
Lordship, 23rd, Lordship.
learned counsel and Inti Wapang, appearing for the respondent, has prayed for listing the matter on 23rd June. Learned counsel for the appellant has no objection, list the matter accordingly on 23rd June.
Obliged, Lordship.
May I please, Your Lordship. Lordship, I beg to mention item number 8 and 9, Your Lordship, for the respondent, Your Lordship.
Hmm.
Lordship, here we yet to file a reply, Your Lordship. The matter can be listed on 24, Your Lordship,
You are for?
the respondent. For both item 8 and
You
9.
want to file affidavit in opposition?
Yes, Your Lordship.
Learned counsel appearing for the respondent prays for some time for 3 weeks.
Your Lordship, if the matter can be listed on 24th of June, Your Lordship, since the leading counsel is from out of station, Your Lordship.
Prays for some time to file his affidavit in opposition and prays for listing the matter on 24th,
Lord.
24th June. This accordingly, learned counsel for the petitioner, you're for the petition.
I'm appearing on behalf of Bendang Wapang, Your Lordship.
Yes. Learned counsel for the petitioner, appearing on behalf of Bendang Wapang has no objections. List the matter accordingly on 24th June.
Lordship, much more. Please, Lordship. Lordship, I'd like to mention item number 3, Your Lordship, from the motion.
Hmm.
Lordship, here the leading counsel, Eliville Sound. He
Hmm.
is out of station, Your Lordship, so if this matter can be passed over, Your Lordship.
For the day?
Yes.
Item 3, motion pass over for the day on the prayer of the learned counsel for the petition.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 6.
Kindly grant us 2 weeks time to file our reply.
Learned Council for the petitioner prays for 2 weeks' time to file their reply to the affidavit in opposition of the respondents. Prayers allowed is the matter of the 3 weeks.
2 weeks.
2 weeks. Learned Council, such and such appears for the respondents. Two respondents, I think.
Yes,
State respondent, Hipapong and CJC. Yes.
Much obliged. May I please your lordship? Lordship, I humbly beg to mention item 10. If your lordship may pass over for a day, this matter.
Item 10, pass over for the day, on the prayer of. for
Azo.
Mr. Azo.
Lordship. IE is listed along with the main case, Lordship. In the main case, Lordship, some necessary order required to be passed by this court, Lordship. Because there's urgency in this case. On 6/5/2025, I filed my affidavit of opposition. I'm appearing for respondent, private respondent, some of the private respondents, Lordship.
Hmm.
Private respondent number 6, 11, 16, 19, and 32 in the main case, Lordship.
Hmm.
I'm also opposite party in the IA.
Okay.
I filed my affidavit of opposition on 6/5/2024. And my
6/5/2024.
lordship, and the government also filed their affidavit.
Hmm.
And also the other private respondent, they've already filed. Now, in view of the interim order, all the headmaster boards of 176 governmental school could not be filled up. Therefore, lordship, this matter requires early disposal. And the petitioner is yet to file affidavit in reply, despite the fact that I filed my affidavit of opposition on 6/5/2025. Therefore, lordship,
Then at least the IA will hear tomorrow.
Lordship.
in the main case, some necessary order required to be passed, lordship. Therefore, may I breathe that, lordship, this matter will go off
Then let it
as
come
per the
up.
list.
Yes, let it come up. We'll
As per the
see.
list.
That's why,
yes, lordship.
let it be called, and then if you necessary, you mention that.
Lordship.
Yes.
Even the IA, there's an urgency because all the applicants were in a zone for consideration of promotion. And even by the PNR, clearance has been issued.
Mm.
However, due to the interim order, our promotion has been kept on hold.
Okay. We'll see when the matter reaches.
Lordship.
Yes, please call. Or
For
any more,
motion.
actually?
For motion, item number 1.
May it please your lordship.
Yes.
Lordship, on compromise between the parties, my lord. So this quashing application has been filed, my lord,
Mm.
under section 528, my lord, for quashing of an FIR and subsequent criminal proceeding, my lord. What has happened, my lord? The matter has initiated from an FIR, my lord. She will get it FIR at page 20. Both the informant as well as an accused person have come together before lordship for quashing of this FIR, my
Okay,
lord.
joint
Joint
petition.
petition, my lord. And basically, my lord, this FIR is basically of return of money, my lord. So I will just read an FIR, just,
Okay.
yes,
please
my
read.
lord, yes.
Page 20.
Page 20, my lord, this is an FIR, my lord. So to the officer in charge, Sawavan Police Station, Dimapur, my lord. So I'm reading the relevant portion number that in reference to subjects cited above, I have honor to state few lines for your kind perusal and necessary action. That I am the resident of so and so, so and so. Secondly, on 15th August 2024, I entered into an agreement with Mansoor Ahmed, proprietor of so and so. As per the agreement, I have granted an amount of rupees 15 lakhs only to him with a promise that he will open a dealership here in Dimapur and supply goods and services to me. And on default to uphold the promise, an amount of 15 lakhs shall be returned back to me within January 2025 without fail. However, after the agreement was entered and the payment was made to Mr. Mansoor Ahmed, he deliberately started to ignore my calls and on different occasions and would often give excuses when asked about the dealership deal. Then even after a stipulated period of time got exhausted, Mr. Mansoor Ahmed failed to uphold the agreement conditions and failed to repay me back the amount of 15 lakhs, even on constant reminder. Ironically, he on many occasions on being confronted about the payment would retaliate and verbally abuse me by saying that he will not give me back my money and take and to take legal action against him if possible, mentioning that he always to abscond from his kind of situation. That I have been left deplorable state because of Mr. Mansoor Ahmed and have suffered huge loss and I
Can
am
we have
humbly
some
business.
quiet,
So, my lord.
disturbing.
Yes.
Yes.
So, my lord, so ultimately, my lord, at page 21, the last para, my lord, his whole affair is for recovery of that money, my lord. Lordship may kindly come to next page, my lord. Thereafter, he said about 2 checks has been given, and thereafter at page 21, he said, despite of my untent dozen effort to claim back my money from so and so, it has all gone in vain as he is not answering my call anymore and is deliberately trying to ignore me from paying back my money. So I have rendered my trust in him and have shown enough patience in dealing with him. But now it is clear picture that Mr. So and so was not taking undue advantage of me and my trust and his malafide intention. So as such, your esteemed authority kindly look into the matter and arrest so and so so that I may able to recover my money. So, my lord, this case is all about, my lord, the recovery of the money, my lord. So thereafter, on the basis of this FIR, my lord, the person was arrested, my lord. My lord, I will take your lordship there at page 25, my lord. That is the forwarding report, my lord. So by this, my lord, on 12th of January or 12th of May, my lord, he was arrested, my lord. And thereafter, he was produced before the Honorable Chief Judicial Magistrate, Dimapur, my lord, on 13th, my lord. So this is the forwarding report, my lord. The second paragraph, it says during the process, prayer was made before the honorable court for issue of the NBW against the so and so. Accordingly, NBW was accorded. Accordingly, on the strength of MDW issued by the honorable court on 11/5, self along with so and so went to proceed to Gauhati to execute the warrant, and on 12/5, with the assistance of the local police, the alleged accused so and so was arrested from Gauhati, and my lord, thereafter, my lord, he was produced, my lord. Thereafter, my lord, lordship may kindly see, oh, my lord, the next paragraph, the matter has been compromised, my lord. Lordship may kindly see the next page is page 26, my lord. My lord, since he was arrested, my lord, so Nurul Haq is an informant, my lord. Lordship may see, my lord, Nurul Haq, my lord, is an informant, my lord. And Manjur, my lord, is a younger brother of the accused person, my lord. Since he was in custody, my lord. So the compromise has been entered on behalf of the younger brother, elder brother, my lord. Manjur Ahmed has entered into an agreement, my lord. So, my lord, I will.
Manjur Ahmed is the
He-
elder brother of
He's a,
the accused.
no, man, he's a younger brother, my lord. Elder brother is the accused, my lord, alleged accused, my lord. So thereafter, both the parties have entered, and he, on behalf of his elder brother, my lord, has make a compromise deed. But here, my lord, in this petition, both have come together, my lord. Both the informant and the accused has come together, my lord. So I will just read, my lord, that's operative part, my lord. Page 26, my lord. Now, whereas an FIR was registered, FIR number so and so, PS server 1 under section 318416. Was registered against an elder person of the elder brother of the second party on the information of the first party. The said affair is still under investigation and charge sheet is not yet filed in the court. And whereas an effort and attempt were made by the friends and elders as well as the respectable people of the society, thereby clarifying all the bona fide mistake understanding between the parties, the first party has thus agreed to withdraw the complaint against the elder brother of the second party, and parties shall make statement before the court or police authorities in this respect as and when required. All the dispute between the parties stand finally resolved, and there is no ill will or complaint against each other in any manner. The parties has thus decided to file a petition for withdrawal of an FIR on the basis of compromise deed on following terms and condition. The first one is, my lord, the first party has lodged an FIR for recovery of the money from which he has given to the elder brother of the second party on to open a dealership and supply of materials, goods and services to him, and on default to uphold the promise, the amount of 15 lakhs shall be returned. And second condition is very important. The first party has received the entire amount from the second party and do not have any outstanding as such. The first party will approach the court or police to withdraw of the said affair, that this matter can be treated as a settled matter and no party will go to any litigation in any court of law. And whereas this compromise deed has been executed between the parties with their mutual consent and free will, without any pressure, force, coercion, undue influence from any side, the parties have decided to end all the dispute and to live peacefully, my lord. So this is what, my lord, the compromise has been entered. In view of that, or my lord, the compromise, my lord, he was granted bail by the court below, my lord. Lordship may kindly come to page 28, my lord. I will just read the operative part, my lord, the last paragraph, my lord. So I will read just the last 3 paragraphs, my lord. Council so and so submitted the third paragraph from below, my lord. That the instant case has been compromised between the parties and the case is, and the accused is in hard patient requiring constant medical attention. As such, he prayed for release of an accused on bail pending the investigation. Learned so-and-so has not objected. PP has not objected to the bail petition since the case has already amicably settled between the parties and IO has recorded his evidence. Considering the submissions and in view of the amicable settlement between the parties, it is considered opinion of this court that the bail ought to have been granted if the attendance of the accused can be secured through a trial through a sufficient reliable sureties. Accordingly, the bail petition of the accused is allowed on following terms and conditions, my lord. And thereafter, my lord, one of the condition is that, my lord, he has to cooperate. He has to cooperate with the investigation, and he shall not hamper the investigation. Secondly, thirdly, my lord, accused person shall have to appear before the court on 7/7/2025, my lord. Now, my lord, what has happened, my lord? Out of these sections, my lord, 318, lordship will may kindly come to page 18 once, my lord. The case has been registered under section 3184, my lord. Page 18, my lord.
Page 18.
Yes, my lord. The case has been registered under section 3184. That is, my lord, earlier, my lord, 420, my lord, IPC, my lord. 3184 is cheating, my lord. Previously, my lord, it is 420 IPC, my lord. This is compoundable, my lord, with the permission of the court. As per section 359(1), my lord. The previous, my lord, section 320 of CRPC, my lord. And my lord, 3165 is, my lord, the previous 409, my lord, criminal breach of trust by public servant, agent, managers, my lord. Yes, this 409, my lord. So, my lord, I am before your lordship because, my lord, compoundable 420, my lord, 3184 is compoundable with the permission of the court, but 3165 is non-compoundable, my lord. So since it is non-compoundable, my lord, so I am before lordship for quashing of the NFI because the compromise is entered and lordship.
Okay,
And
give some time to obtain the CD. At
Yes,
least
yes.
certain the
Status
facts.
report, yes, sir.
Yes. status
What I am
report.
praying, my lord, in the meantime, my lord, this since I am being called to appear in the court, yet proceeding of that page, my lord, 28, my lord. The proceeding of GR case may be stayed, my lord. What I am praying, my lord, since
Your Lordship,
nothing,
the accused has to appear on 7/7.
yes.
So within that time, like, the CD will come. So there's no question of staying. also.
Yes, 7 is
Yes. July, Your Lordship.
Yes, July, my lord.
July.
Yes,
Yeah.
my lord.
Yes,
Now we are in June.
we are giving them 1 week.
Yes.
Yes, my
1
lord.
week.
What I
within
am
that
praying, my lord, yes,
Yes.
lordship may,
Within that time, we can dispose it off also.
Yes.
Yes.
but my lord, sometimes it takes some longer date also, my lord. It may cross that
No,
because
no,
I think, my lord,
Maybe in principle seat and all, but here, when we
Yes.
fix it, it will come up.
since the, my lord, since the appearance has been granted, my lord, so my lord, may I pray, my lord, because ultimately the matter has been ended, my lord, because it is a civil dispute within the parties and my lord, all the judgment, my lord, right from Gyan Singh and all others.
Your Lordship is no way going to affect because it's fixed on 7/7.
So,
And the matter will come up
but
after 1 week.
in any way, it's already compromised.
He is compromised, my lord, so my lord,
It
nothing will,
remains actually.
yes.
Yes.
Appearance also
Okay.
tough.
Well, You are, Mr.
G alone, my lord.
This is an application under section 528 of the BNSS, praying for quashing of the FIR dated
But PS case, my lord. Savarman PS case, my lord.
with your FIR is
My lord, 26/4, it is registered on 26/4, page 18, my lord.
okay.
Second line, my lord.
Where is it?
My lord, the second line at page 18, my lord.
Okay, 26/4/2025. In suburban PS case
21 or 25.
21 of 2025 under section 318, clause 4/316 clause 5 of the BNS. So Learned Counsel, Mr. G. Alam, has submitted that this is a joint application by the informant and the accused, praying for quashing of the FIR and the proceedings on the basis of a deed of compromise, which was executed between them on the 13th of May, 2025. So, next para, Learned PP enters appearance on behalf of the state respondents. Leaves the matter after 1 week.
Your Lordship, since it's in Dimapur, so 2 weeks, so that the city can come.
Okay, we'll give a fixed date then.
13, my lord, can it be, my lord?
Fixed on 13 June 2025, on which date the learned PP shall obtain the scanned copy of case diary and the latest status report. Stop. In the meantime, the proceedings of the GR case 180/2025 before the learned Chief Judicial Magistrate Dimapur shall remain stayed till the next returnable date.
Obliged.
Much obliged.
For motion, item number 2.
May I be permitted to represent the petitioner, Miller, through virtual mode, Miller? I'm sorry that I couldn't come physically, Miller. This is a FIR regarding this cheating, criminal breach of trust and misappropriation of fund thereof, Miller. May I be permitted to read out the FIR, Miller? This was filed lodged on 13/11/2023, Miller, filed before the officer in charge is Police Station, Dimapur, Nagaland. Maybe the subject FIR on account of cheating, criminal breach of trust, misappropriation of money thereof. Sir, with reference to the above cited subject, it is to inform you that for your necessary action, please. That's, sir, Srimati so-and-so, herein after referred to as victim resident of so-and-so, is a known person and close associate to me. As such, in the year 2019, Smriti Naro alias Esther, as accused number 1, has introduced Reverend Timothy Joshua alias Joshi to as accused number 2 for a business deal. That Reverend Timothy Joshua introduced Sri Rakesh Singh. Herein after referred to as accused number 3, allegedly to be a farmer from Calcutta. The victim subsequently, Sri Mahesh Awasthi, herein referred to as accused number 4, managing director of RM Trading Association, was also introduced by Reverend Timothy Joshua to the victim. That's accused number 3, who alleged to be a farmer from Calcutta, has alleged to find an article preliminarily analysis to be mystery machine. Mystery machine description of the machine is given below from his farmhouse and has offered for the sale to the victim through accused number 2, whereas the mystery machine was offered for a sale to the tune of rupees 4 crores, with a proposition that accused number 4, being the MD of the alleged company RM Trading Association, who have assured the victim that the alleged company shall buy back the said machine to the opening of amount 22,004 crores if the victim first buy the said machine by making payment of 4 crores as part of the fulfilling the prerequisite formalities, after which the alleged company shall buy back the said machine as per the promise. The description of the machine, Miller, that, sir, it is pertinent to mention that accused number 2, being a religious person and holding icon post of reverend according to the Christian faith, with great ability to pursue others. As such, the victim also fall prey to the accused number 2 fictitious story, and as a result, the victim could not resist the approach of the accused number 2, and thereby agreed to purchase the said machine for the consideration of 4 crores, which is turn the said machine will buy back by the RM Trading Association company. Pursuant to the Pursuant to the said deal, an agreement was also executed between RM Trading Association and accused number so and so agreement was attached. That's according to the said deal with the victim in the order to effectual an agreement to the purchase of said machine have transferred the amount in a series of order has been enumerated under. Milord, I'm not reading out this payment made me Milord entire, but the entire amount is 3 crores 50 lakhs has been paid. That it is pertinent to mention here in that apart from the above bank transaction, another sum of rupees 45 lakhs, which is entered in the serial number 23 on the table, has been transferred to the accused account through a friend's bank account. Further, it is also pertinent to mention that serial number 24 on the table, an amount of rupees 48 lakhs 93,391 is yet to be ascertained as the said amount is transferred through a friend account and the evidence for the said transaction is yet to produce. However, I am ready to furnish the transaction record if it is required in the investigation process. That's after the said payment, the series of conversation, the deal was stalemate as the accused number 3 did not reveal or show the machine to the victim. However, based on the trust, the victim was still optimist to accomplish the deal, but all this time of the waiting has went in vain when all the accused stopped receiving the victim call and so also keeping the phone switch off, which have further ignite the suspicious on the entire deal. Then particulars of the accused phone numbers, Miller, for accused that, sir, it is distressing to know that all the accused have stopped responding after the above stated payment. Further, sir, I have an apprehension that this is not the accused's first crime, but must have a criminal antecedent which is threat for the society at large. Therefore, sir, I kindly request the concerning authority to register a fire all the accused under relevant section of the Indian Penal Code. Then, sincerely, Kuto Chioto addresses from Nagaland, Miller. And this alleged victim has never come and known to the petitioner, Miller. This petitioner is never named in FIR, Miller, in the four corner of the FIR, Miller. And after the arrest of the this accused number 1, Miller, kindly turn over the page, Miller, page number 38, Miller, annexer P5. IU had made the prayer, Miller, date 3/1/2024. Present IU of the case, ASI so and so of East, received an application from the IU of the case praying for the issuance of non-bailable warrant, NBWA, against one Anup Gadal, resident of Pradhan Nagar, Silguri, Darjeeling, under Pradhan Nagar PS. I have gone through the application. I have also heard the IU of the case, and it appears that no notice has been issued to the aforementioned Anup Gadal prior to the application being moved for issuance of non-bailable warrant. Under the circumstances, Honorable Court is declined to allow the prayer of the IU of the case, Miller. Honorable Court was pleased
You're not
to
listening to the court at all. You're just going on and on. You're not listening to the court.
Miller, I'm
At
sorry.
least stop and listen. Yes.
Miller.
Which page are you reading from?
Miller.
Which page are you reading from?
Page number 38, Miller. 38, wherein Milord, this IU has made an application praying for the issuance of non-bailable warrant.
Okay.
And it was rejected by the Honorable CJ Milord. But despite the rejection, Milord, that IU of the case arrested the accused person, Milord. Prior to that, this is mandatory as per the judgment of the Ernest Kumar versus State of Bihar, and it was been reformed by the Satyendra Kumar Antil and all, Milord. Section 41 notice was to serve because this offense was below 7 years, Milord. Despite that, violating all this, Milord, and this accuser, this petitioner do not know the victim also, Milord. And third party has come into this case, Milord. And victim, being alleged victim being the director of the government department, Milord. And she is not a fool that giving 3 crores 50 lakhs to the accused person on the imaginary machine, Milord. So because of that, Milord, and they have drawn agreement, Milord, page number 41, Milord, during my police remand, Milord, and I am made to pay Milord, 90 lakhs, Milord, during the police remand, Milord. And police is not acting like this investigating agency, Milord, law enforcing agency, Milord. Here, Milord, they are acting like recovery agent, Milord. And the entire affair seems malified, Milord, politically motivated, abuse of criminal process, and arrest made me, Milord. It is violation of the procedural safeguard, Milord, and arbitrary, Milord. And during the police remand, Milord, they made me to pay 90 lakhs, Milord. And even they have taken the check of my wife's, Milord, of 35 lakhs, Milord. And there's no fair investigation, Milord, abuse of judicial process, Milord. And in the same manner, Milord, they have made same kind of arrangement to establish the to collect the funds from other accused also, Milord. During the police remand, Milord, they made to pay the amount from the this accused person and made an agreement. On the basis of the agreement, on the strength of the agreement, Milord, this accused person was enlarged on bail, Milord. Even I was in this custody for the period of 12 days, Milord. And I was enlarged on bail after this payment of 90 lakhs to the alleged representative of the victim, Milord. So considering all these facts, Milord, this is purely a process of this abuse of process of law, Milord. If there is any agreement between other people also, this is purely a civil dispute, Milord. But police and as well as this representative of the alleged victim is using the criminal means to extort money, Milord. So considering all these facts, Milord, I have come before Lordship Court for the quashing of the FIR, Milord, and kindly serve the notice to the respondent, Milord. In the meantime, kindly stay the this proceeding in the lower court, Milord, this subordinate court, Milord.
Notice. Yes.
Yes.
Coming at this stage. Yes. This is an application filed under section 528 of the BMSS, praying for quashing of the FIR in East Police Station case number 274/23 under section 420/406/403/120B IPC and the proceedings thereof, pending trial before the learned Chief Judicial Magistrate Dimapur. Learned Counsel, Mr. Your name?
Pratap Khati.
Such and such, appearing for the petitioner, has submitted that the present matter is of purely civil nature and stated that you were also not named as an accused, isn't it?
Yes, Milord. Not named in FIR, Milord.
But he has not been named in the FIR. However, he had been arrested and under duress during his custody, he was compelled to execute a deed of agreement dated 15/2/2024, agreeing to pay rupees 90 lakhs immediately and
I had already paid, Milord.
okay, and an additional rupees 39,100, 3 installments. Learned Counsel submits that this amount of 90 lakhs you have paid.
Yes, Milord.
Has already paid the amount of rupees 90 lakhs. So, Learned Counsel has therefore paid for quashing of the FIR and the criminal proceedings thereof on the above grounds. Stop. Issue notice, returnable within 4 weeks.
Milord.
The petitioner shall take steps for the respondent number three, you'll accept for one and two, no? For the, one and two, yes. For the respondent number three, by registered post with AD and also through usual process within a period of 3 days from today. Learned BP as Mary appears, has entered appearance on behalf of respondent number one and two in accordance with formal notices called for as far as the state respondents are concerned. List the votes.
Kindly stay the proceeding for the Milord, for the time, Milord. Interim stay, Milord.
Oh, your lordship, at least
We'll
opportunity.
consider on the next
Yes,
day.
yes.
The interim prayer shall be considered on the next date.
Grateful, Milord. Grateful.
My ladyship, case diary may be called in this.
Yes,
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 Just a small
Get
request
copy
of
of
case diary.
is the real
And the same may be supplied if a scan copy is being filed, my ladyship.
and copy of case diary, as well as the latest status update.
Much obliged, my lady.
For orders, item number 10.
Okay. Right.
May I please, Lordship? Lordship, the instance IA 67 is preferred for modification.
Give me the IU also. This is the main case or I?
IA.
Okay, okay. Yes, this needs expeditious disposal because
Lordship, Lordship,
because of the interim order, the vacancies are not being filled.
Lordship. Lordship, I humbly pray if this matter can be possible for tomorrow.
For the
For hearing of the IA.
For the IA, I have nothing much to say, Lordship.
Mm.
However, my prayer is necessary order may be passed in the main case because affidavit and opposition has already been filed.
Mm.
And petitioner is yet to file their reply, Lordship.
Lordship, for the reply, we're in the verge of completion. So
Lordship,
if
that is
necessary,
recorded.
Lordship.
And this matter will be fixed for admission hearing, Lordship. The main case, I mean,
Mm.
not the IE. Next week, Lordship. I'm making submission in the main case, Lordship.
Yes, yes. Learned Counsel, Mr. Wati Jamir, appearing on behalf of respondent number
Respondent number 6,
6,
11,
11,
16,
16,
19, and 32,
and 32.
and WBC, Lordship.
Yes, in the main case, okay, has prayed for listing the matter, the present matter on next week, 16th.
Lordship.
Okay, that's 2 weeks, huh?
On
It's okay.
16, no, next week, Lordship.
Next week will be 9, 10,
Then and then,
10th, on 10th, for admission hearing, as the affidavit in opposition has already been filed by the respondents as far back as
I filed my affidavit, Lordship, on 6/5,
on 6/5/2024.
25, Lordship.
No, 20, on 6/5/2025. Stop, this state filed, and the state respondents have also filed their affidavit in opposition, whereas the petitioner has not filed any affidavit in reply till date. Stop. Accordingly, it is made clear that before the next date, the petitioner shall file the affidavit in reply, if so advised. And the matter be listed for admission hearing on 10th. Yes.
Obliged.
Much obliged. Lordship, there's an interim in the made read petition.
The interim order passed earlier shall continue to the
Lordship.
next date.
And with regard to
the
IA,
next
it will be listed tomorrow. IA, for IA,
IA, yes, and the IA passed over for the day.
much obliged. Obliged.
Item number 11.
who are
I'm for the
responding
respondent one and two.
1 and 2.
Yes. Now, the respondent number one and two, we are raising three objections for the,
Okay, 1 minute, let me just
Yes.
find the documents. There's so many pleadings. Okay, yes.
yes. Or the state's objection is threefold. First is on the maintainability of the petition, on the ground that they have not exhausted the alternative remedy which is available, but I leave that to the discretion of the court. Secondly, on the local standing, to challenge the petitioner has assailed the appointment as well as the absorption and promotion of the private respondent. Now we are raising the argument that there is no local standing to be raising such argument because of the fact that the petitioner as well as the private respondent, they belong to different cadres or streams in service. Thirdly, the impugned DPC, which has been assailed in the petition, is not illegal, but it has been the DPC procedure has been carried out in accordance with Rule 29 of the service rules. On that threefold contention, I would like to take your lordships to the, before that, the NIDC, respondent number 2, NIDC is a government company. Now, if your lordship may have page 33 of my affidavit, it is a government company. I have enclosed the memorandum and the articles of association. I will not be going through that, but just for your lordship's reference.
Affidavit of respondent number 1 and 2, no?
Yes. One. I think your lordship has that.
Yes, this is the one.
Page 33.
It's the memorandum of association.
Yes, I will not be going through that, but if your lordship may have page, this is the memorandum and the articles of association based on which the NIDC was formed, registered as a company under the Companies Act. Now at page 47, clause 31.
Clause 31.
Clause 31, yes. It specifies, now the NIDC is managed by its board of directors. All the decisions which the NIDC takes, it's only the board of the board of directors which takes it. Now the clause 31 and clause 32 empowers the board of directors to take decisions, and clause 32 specifies that in the next page, the directors may, as and when they think fit, make any bylaws not inconsistent with the objects of the company as set out in the memorandum of association. Okay. Set out in the memorandum of association, nor with these articles for the conduct and regulation of the business of the company, and may in like manner vary and repeal any such bylaws. Now, based on this, the NIDC service rule was enacted in 1991. Now, at the outset itself, I would like to submit that the NIDC is not a statutory authority, or the NIDC service rule is not statutory in nature. It is merely a company formed in accordance with the provisions of the Companies Act. And merely because of the fact that the board of directors has enacted a regulation or rules called the NIDC service rule, that does not make it statutory in nature. The NIDC itself is not statutory in nature. Now, therefore, the contention has been advanced by the petitioner on the last occasion to the effect that when the statute prescribes a thing to be done in a manner or not at all. It has to be done in the manner. That principle will not apply in this instant case. The rules, my submission is, it is administrative in nature, and it may not be enforceable in the manner it has been sought to be enforced by the petitioner in this instant case. Now, I would just like to rely on precedents as I go along with my submission instead of relying at the end. Before that, if your lordship may also have already, your lordship has seen that this service rules on the last occasion, but I would just like to refresh the court's mind. Lordship may have page 53. The service rule, I have enclosed that in my affidavit as well. Yes, page 53.
Which page?
53. Page 53. And if I may be allowed to read the preamble at page 58. 58 is the preamble. Whereas it is felt necessary to frame rules defining the terms and conditions of service of the employees of the Nagaland Industrial Development Corporation Limited, and whereas the corporation is an undertaking of the government of Nagaland to be run on business lines, these rules are to be interpreted keeping in view the ultimate objective of the organization, that is, continued accelerated growth of the corporation as enumerated in its memorandum of association of the corporation vis-a-vis the normal aspiration of the employees for career advancement. The board of directors hereby frame and adopt the following rules. Now, it was in this manner, in the year 1991, the board of directors framed these rules called the NIDC service rule. Now, this I'm placing an emphasis on the sentence to be run on business lines. These rules are to be interpreted because this, in my humble submission, this will later on come to the, as to regarding the selection of the petitioner compared to the respondent, as to why the private respondent was selected. Now, regarding the contention that the NIDC is not a company and its service rules of 1991 is not statutory in nature, I am relying on the first president. This is 1975 1 SCC 421, flagged as number 1.
Sukhdev Singh.
Yes, paragraph 25. Para 25. The additional Solicitor General submitted that regulations could not have the force of law because these regulations are similar to regulations framed by a company incorporated under the Companies Act. The fallacy lies in equating rules and regulations of a company with rules and regulations framed by a statutory body. A company makes rules and regulations in accordance with the provisions of the Companies Act. A statutory body, on the other hand, makes rules and regulations by and under the powers conferred by the statutes creating such bodies. Regulations in Table A of the Companies Act are to be adopted by a company. Such adoption is a statutory requirement. A company cannot come into existence unless it is incorporated in accordance with the provisions of the Companies Act. A company cannot exercise powers unless the company follows the statutory provisions. The provision in the Registration Act requires registration of instruments. The provisions in the Stamp Act contain provisions for stamping of documents. The non-compliance with statutory provisions will render a document to be of no effect. The source of the power for making rules and regulations in the case of corporation created by a statute is the statute itself. A company incorporated under the Company Act is not created by the Companies Act, but comes into existence in accordance with the provisions of the Act. It is not a statutory body because it is not created by the statute. It is a body created in accordance with the provisions of the statute. And therefore, the NIDC is not a statutory entity. Secondly, the next authority is 2095 SCC 515, flagged as number 2, paragraph 23. Paragraph 23. This is regarding the nature of the service rules.
Yes.
the Indian Airlines Corporation Employees Service Regulations 1955, which are made in exercise of the powers conferred upon the corporation by the Act, are undoubtedly statutory in nature, but the recruitment and promotion rules are not statutory in nature. These rules are not framed in exercise of any rule-making power. Mere administrative rules are not legislations of any kind. They are in the nature of statements of policy and the practice of government departments, statutory authorities, whether published or otherwise. Statutory rules which are made under the provisions of any enactment and regulations subject to parliamentary approval stand on entirely different footing. The administrative rules are always considered and have repeatedly been held to be rules of administrative practice merely, not rules of law and not delegated legislation, and they have no statutory force. Mere description of such rules of administrative practice as rules does not make them to be statutory rules. Such administrative rules can be modified, amended, or consolidated by the authorities without following any particular procedure. There are no legal restrictions to do so as long as they do not offend the provisions of the Constitution or statutes or statutory rules, as the case may be. Now, the NIDC service rule has not been enacted by borrowing or say has not been enacted through a statute. There's no statute as such. There is no statute empowering the the directors of the NIDC to enact the service rule. It's a government company, and only for the benefit of its employees, the rules has been enacted for the benefit of the employees. Therefore, the rules is not statutory in nature.
But they have to be guided by certain.
Yes, and they are guided by the administrative rules, which is the service rules. Now, whether it's enforceable or not, that may be a different question. But in a context of this case, my submission is that in view of the contention I'm raising, especially the locus standi of the petitioners who challenge the appointment, and also the non-violation of Rule 29, which we will come later on by the DPC, the question of enforcement may not even arise in this case. Now, coming to the objection on the maintainability of the petition. I'm raising this objection because from the representation which was addressed by the petitioner before the petition was filed, the main heartburn or the main grievance of the petitioner is with respect to seniority only. The seniority only. She is not aggrieved with the appointment or the regularization. No. It's only with the seniority. Now, seniority is not a fundamental right, as your lordship knows, and therefore it is only in this regard that I am raising the objection on the maintainability. Now, the representations, since only the relevant extract I may be allowed to point out. Page 98 of the petition.
Of the petition.
This is the first representation. Page 98. Now, of course, the petitioner referred to the appointments in her representation, but if your lordship may have at page 99, what is the prayer or the relief which was sought from the MD? The last paragraph. In these circumstances, I submit this representation and request the NIDC to rectify the seniority list and correct my position therein vis-a-vis my colleague so-and-so within 15 days, failing which I will be compelled to seek just so-and-so. Now, again, even in the second representation, page 116. And your lordship may also know that these representations, both these representations were addressed only to the MD or again to the commissioner and secretary of the commissioner and secretary, who is the respondent number one. It was never addressed to the board. That's why I'm raising the contention or the argument that the rule 4, which I will be adverting to now. Now, the second representation, page 116, and again at page 117, page 117. Again, the petitioner seeks in these circumstances, I submit this representation requesting you to review the notification, which was the seniority list, and restore my seniority above my colleague. That is the respondent number 3. In view of this, if your lordship may once again have the service rules in my affidavit, page 63, the relevant portion, rule 4 as already page 63, the proviso to rule 4. If any employee feels aggrieved as regards the interpretation or implementation of any of these rules, she shall have a right to appeal to the board, whose decisions shall be final and binding on all concerned. Now, I'm submitting that this provision has not been utilized by the petitioner. And only on this ground, I'm raising the objection on maintainability, because the argument that even if the petitioner submits a representation, it'll merely amount to filing another petition before Caesar's wife. That may not stand, because the service rule, now this is not a statutory rule, but it provides an intra-house grievance to intra-house redressal of grievances. Now, therefore, this provision has been included, or else what is the purpose of including this provision? The representations were not addressed to the board except to the MD. Now, the MD is not above the board. The board is the ultimate authority which takes a decision for the company in all processes. Therefore, having failed to utilize this provision, the proviso to rule 4, I'm submitting that the petition is not maintainable, because this court may also have the benefit of the board's view as to how, if the petitioner had placed her grievances before the board's view, and the board's view is may or may not be in consonance with what the petitioner wants, but later on the petitioner can file a petition, and the court can have the benefit of the board's view as to how or in what manner they have placed the petitioner in such situation. It is only in this background that I'm raising this objection on the maintainability, subject of course to the discretion of this court. Now, in this regard, just 1 or 2 authorities I may be allowed to rely on. If your lordship may have flag number 3. That will be 2007 10 SCC 548. On the well-settled principle that seniority is not a fundamental right. Paragraph 25. Paragraph 25 says, seniority may not be a fundamental right, but it is a civil right. Infringement of the said right would be permissible only if there exists any rules validly framed under a statute, which is not the case in this case, in this petition, and or the proviso appended to Article 309 of the Constitution of India, which is also not the case. It cannot act in a vacuum. Any rule taking away such rights would deserve strict construction. And therefore, since the petition is not seeking enforcement of any of our fundamental rights, except for seniority, placement in seniority, I'm submitting that this petition is not maintainable at this instance. Secondly, on the principle as to how the high courts are to act.
What about the prayer in the petition? Prayer in the petition is.
Yes. Of course, the prayer is omnibus to the extent of challenging the appointment, which I will come later, because she has no locus standi. Now, the second serial number 4. On the principles as to how the reed court is to exercise its jurisdiction. 2021 SCC online SC 801. Paragraph 25. 25. Just part of it. May I read?
Yes.
While a high court would normally not exercise its writ jurisdiction under Article 226 of the Constitution, if an effective and efficacious alternative remedy is available, the existence of an alternate remedy does not by itself bar the High Court from exercising its jurisdiction in certain contingencies. This principle has been crystallized by this court in so-and-so, so-and-so. Recently in so-and-so, a 2-judge bench of this court, of which one of us was a part of, has summarized the principles governing the exercise of writ jurisdiction by the High Court in the presence of an alternate remedy. This court has observed the principles of law which emerge are that the power under Article 226 of the Constitution to which writs can be exercised not only for the enforcement of fundamental rights but for any other purpose as well. 2. The High Court has the discretion not to entertain a writ petition One of the restrictions placed on the power of the High Court is where an effective alternate remedy is available to the aggrieved person. Exceptions to the rule of alternate remedy arises where the writ petition has been filed for the enforcement of a fundamental right protected by part 3 of the Constitution. B, there has been a violation of the principles of natural justice. C, the order of proceedings are wholly without jurisdiction. Or D, the virus of a legislation is challenged. 4, an alternate remedy by itself does not divest the High Court of its power under 2 to 6 of the Constitution in an appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternate remedy is provided by law. Till that much, I will not be reading the other ones. Now, therefore, it is my submission that since of course, in addition to the objections which are raising regarding the locus standi, insofar as the petitioner's challenge to the appointment regularization is concerned, since the primary grievance of the petitioner is with regard to the seniority, and seniority not being a fundamental right, I'm submitting that this petition is not maintainable because of the petitioner's failure to exhaust the proviso to rule for the service rules of an IDC. Now, the second bone of contention of the state respondents with regard to the locus standi of the petitioner. Now, since we are raising this ground, I may be permitted to take a lordship to the records which I've enclosed in my affidavit, just to show just to show how the petitioner is placed along with the private respondent. The post of legal officer. Now, this was not there when the 1991 rules was framed. The lordship will see that it was not there. Only only in 2001 it was brought into service rules. That has not been, of course, alluded to by the petitioner in his submissions earlier on. But I'll take that to your take your lordship through that also. Therefore, if your lordship may kindly bear with the documents which I'll be referring to, and just to see how the post of legal officer, the post was enacted in the service rules of the NIDC. Now, before that, if your lordship may have page 97 of the 1991 service rules.
97.
Yes, this is annexure 1, specifying the channel of promotion for the various posts. Now, this annexure 1, channel of promotion, the heading reads, the channel of promotion indicating minimum length of service in each cadre to become eligible in the next higher cadre. Now, the petitioner's entire contention has been to the effect that there is no cadre specified in the service rule, but ever since 1991, there has been a specific maintenance of cadre or stream in the NIDC service rule, which your lordship would see in 1991, as well as 2001, as well as 2016. Now, from this annexure 1, your lordship would see that at serial number 12, initially when this 1991 rules was enacted, only this cadre was allowed to reach the post of GM, general manager. All the others all the other cadres are excluded. Only it is this serial number 12, assistant manager. Next is the manager. Next, promotion to deputy general manager, and the next to general manager. Subsequently, this was changed. But this is the cadre which we are concerned with. Now, before this rules was enacted, there was already a post of legal officer. So allow me to just take a lordship to certain history as to how this post of legal officer came into being. Starting from page 107. I'll be referring to all the minutes of the board of directors meeting.
Yes.
This is the
107.
64th meeting held on 8 December 1979. The relevant resolution is resolution 5B in the next page, page 108. Five B.
5B.
Yes. The board sanctioned and created a post for an assistant legal officer in the scale of so-and-so, and desired that the candidate to be selected should be a law graduate and should have the requisite qualification to practice in the courts of law. The executive director was authorized to constitute a selection board and to appoint a person in the above post. Now, this was how, insofar as we could ascertain from the records, the board of directors created this post of assistant legal officer. Now, the next page, 109. Next page, 109. This is, I'm referring to at the bottom of the page. This is the 89th meeting of the Board of Directors held on 26th August 1983. And then continue to the next page. There was a change of terminology at resolution 3.5. The assistant legal officer, which your lordship had just referred to, was changed to assistant legal manager. And then the
Assistant legal or at serial
yes,
number
sorry,
9.
sorry, yes, serial number 9. I'm sorry. And now your lordship may have the next page. One. This is another meeting minutes of the 118th meeting minutes of the BOD held on March 8, 1990. In the next page is a relevant resolution. Resolution number 6. Upgradation of the post of assistant manager in bracket legal. The board did not agree to the proposal for upgradation of the post of assistant manager legal. Instead resolves as follows. Resolved that a new post of manager legal in the scale of so-and-so be created and Sri Sharma, the then incumbent, be promoted to the post of manager legal against these vacancies. Further resolved that the post of assistant manager legal on being vacated by Sri Sharma be abolished for the time being. Now, your lordship may know that this was in the year 1990. The service rule is yet to be enacted by the NIDC. And the post which we are concerned with is manager legal. In the year 1990, the post of manager legal. Now, if your lordship may bear with me and then go back to the service rules again. At page 100, these are the list of posts as framed and created by the NIDC at Annexure 3. Or rather at Annexure 1, Annexure 3, in both the two annexures, your lordship will not find that the post of manager legal was inserted in the service rules. In any of the serial numbers, even at Annexure 1 or at Annexure 3, the post of manager legal was not there. But yes, now thereafter, at page 113, I'll continue page 113. The type copy is at page 114. This person was appointed for the post of manager legal. I'll not be reading out just the first paragraph. We invite your attention to so and so, so and so. We invite your attention to your application dated so and so for the post of manager legal, and glad to advise you that you have been appointed as legal officer on retainer basis with effect from 4th January 1993, initially for a period of 6 months. Now, I've stated in my affidavit that the then incumbent had expired by then. And then because of this, the NIDC was compelled to appoint another person. Now this fellow was appointed. Now, page 115. This is the minutes.
This one was on retainer basis.
Yes, only on retainer. Later on, he was regularized, which I've also enclosed the document. Page 115. This is the 130th BOD meeting held on July 9, 1993. The relevant resolution is resolution number 7 in the next page, page 116. He was regularized. In the post, the lordship may note the second paragraph in the resolution, resolved that Sri so-and-so, who is working on retainership basis in a corporation, be regularized as legal officer in a scale of so-and-so, with effect from so-and-so as legal officer, and the post of manager legal be abolished. Now again, the post of manager legal was abolished. And thereafter, at page 117, the official notification was issued, which I'll not be reading out. And Lordship, we come to page 119 now. A short reference only insofar as this DOD 144th meeting is concerned. Here, or as already alluded by the petitioner in his submission, there was a redesignation of the certain the staff officers to that of assistant manager. Page 112 is the relevant resolution. Page 122. Okay, yes. Resolution number 13. Proposal for redesignation of staff officers and assistant managers of the corporation. The board reviewed the matter for redesignation of staff officers to assistant manager and consequent redesignation of the assistant managers to deputy managers, and opined that while it was agreeable to the proposed redesignation, in no case should the redesignation be linked to scale of pay or comparison be made with other organizations having similar designations, and accordingly passed the following resolution. Resolved that the existing staff officers and assistant managers of the corporation be redesignated as assistant managers and deputy managers respectively, without any change in the existing scale of pay or other benefits presently enjoyed as staff officers and assistant managers, and in no case comparison with other organizations having similar designation would be entertained. Now, this may not be so relevant insofar as the petition is concerned, but just for the purpose of record, I've enclosed it. Page 123. Page 123, the type copy at page 124. The post, as it was existing then, legal officer, it was redesignated as deputy manager legal. And thereafter, at page 125, this is another BOD meeting at the 151st meeting of the BOD, page 125. Held on July 28, 1999. Page resolution 13, page 126, but I'm relying only on one paragraph at page 127. This was how the petitioner was brought into the picture. Page 127, the seventh paragraph.
Yes.
Seventh, starting with the board deliberated.
Deliberated
Yes.
further.
The board deliberated further on matters in relation to poor recovery performance and desired that wherever inevitable, necessary legal options should also be exercised, and as such felt that the performance of the present legal section of the corporation was not satisfactory, and directed that with a view to strengthen recoveries through initiation of legal process, the management should take necessary steps for appointment of a legal officer at the earliest. On being apprised, now this was how the process was carried out. Now, this was followed by the appointment of the petitioner, which I've enclosed at page 129. The petitioner was appointed by order dated 8 October 1999 on ad hoc basis. And thereafter, if your lordship may have page 131. This is where this is the minutes of the 157th meeting. Now, actually, this was preceded by another meeting, which I've not enclosed, but it's self-explanatory from this resolution. At page 132, the relevant resolution which we are relying on is resolution number 16. In this meeting, the board amended its 1991 service rule. This was dated 24th July 2001. Prior to this, the petitioner was not in the service of the board, in the sense that the petitioner's post was not found in the service rules. Only in this, through this amendment, the post held by the petitioner was brought into the service rules. Now, since this amendment is relevant, allow me to take your lordship to certain portions of the resolution. Now, the background, your lordship will find more clarity if your lordship first reads page 133. Introduction. Just one or two paragraphs. Introduction. The board of directors,
133.
yes, 133, sorry.
Background.
Yes, no, the introduction. Under the recommendations, the introduction. The Board of Directors of the NIDC in its 154th meeting held on May 6, 2000 has constituted a committee of directors to study the corporation's service rules with particular reference to the promotional channel and scope for infusion of fresh blood into the workforce of the corporation. The committee was also entrusted to examine all such matters which are awaiting final decision. The committee met on 2 occasions to discuss and study the relevant and connected issues on October 3, 2000 and October 19, 2000. Subsequently, I will not be reading out the other portion, but this was how the committee's report was placed before the board. And in this meeting, the committee's recommendation was approved by the board. Now, in the promotional channel, which was as referred to by the board, is at page 137. Page 137, this is the recommended promotional channel as approved by the board. Now, if your lordship may remember or recall, in the 1991 service rules also, the reference has been made to Qatar. Even in this, the reference has been made to Qatar, just that it has been streamlined. Now, in the recommended promotional channel, A is the NIDC subordinate staff service, B is the NIDC ministerial service, C is the NIDC legal service. This legal service, and E is the NIDC management service. Now, this is where we are trying to draw a point of difference, that the legal service, it has its own cadre. The management service, it has its own cadre. The respondent number 3 belongs to the management service. The private petitioner belongs to the legal service. And it was only by this approval that the legal service cadre or stream was brought into the service rule of the NIDC. Now, at the bottom, note, this is also another relevant portion, relevant part. Promotions, seniority, etc.
Just
Yes.
5 minutes.
May I continue?
Yes.
Now, Your Lordship, we have at the bottom the note which was appended to this promotional channel. Promotion, number one, promotions, seniority, etc. of employees shall be considered on the basis of the respective service cadre only. Now, therefore, Your Lordship may have again an IDC legal service and D. This is the promotional channel from assistant manager legal to deputy manager legal to manager legal. Now, there's in the year 2002, 2001, when this was amended, there was no further scope for promotion for the legal service cadre. Now, in the NIDC management service cadre at E, this is the promotional channel: assistant manager, deputy manager, manager, general manager, and then till the post of general manager. Now, this aligns with the preamble which I've already read out earlier. Now, therefore, when this when this 2001 service rules was amended, the petitioner was yet to be, of course, it was only by this amendment that the post of the petitioner was brought into the service rules of the NIDC. Prior to that, there was no post of legal officer or manager, deputy manager legal, as the case may be, in this NIDC service rule. It is only by virtue of this amendment. Now, therefore, the petitioner's case has to be tested on the basis of this amendment, because the petitioner challenges the appointment of the respondent number 3. Shortly thereafter, the respondent number 3 was appointed on the basis of these rules. Now, in view of this, the education qualification at serial number 2345. The qualification. Now, the qualification for legal service has not been prescribed insofar as this 2001 amendment is concerned. But later on, 2016, it prescribes the qualification for legal service, but the qualification for management service has been specifically prescribed even in the 1991 rules, as well as this amendment. Serial number 2 is the qualification which has been prescribed by this amendment. And the petitioner does not.
This is for the management.
Yes, this is for the management. Minimum qualification for appointment to the post of deputy manager shall be postgraduate, preferably in management, from selected management institutes / universities, masters in economics, statistics, MTech, CA, CS, ICW, and so on. Now, this is the qualification prescribed for the management service, whereas the petitioner does not possess this qualification. Now, therefore, in view of this, we are raising the contention that the petitioner does not have the locus to challenge the appointment of the petitioner, the respondent number 3. Thereafter, at page 114, the petitioner was regularized in service as assistant manager legal. This is in accordance with the 2001. Now we are in the 2001 amendment as insofar as the promotional channel is concerned. And shortly thereafter, at page 142, the respondent number 3 was also appointed. In the interest of the corporation, Sri so-and-so is hereby appointed to the post of assistant manager under the establishment of Nagaland Industrial Development Corporation Limited in the scale of so-and-so plus other allowances as admissible from time to time with immediate effect. Now, this was on a temporary basis. Later on, he was regularized, which has also been impugned in this petition. Now, the next relevant aspect of the matter, page 143. This is the 177th meeting of the BOD held on June 10, 2008. Now, this will also have another bearing insofar as the challenge to the appointment of the respondent number 3 is concerned. Now, the two resolutions I'm relying on, resolution number 8 and resolution number 10. Resolution 8 is at page 144.
Regularization of ad hoc.
Yes. Now, this was the decision of the board to go for regularization of the ad hoc officers and staffs who were in service. Now, this decision has also not been challenged. If your lordship may kindly note that. I will not be reading that out, but the next resolution is at page 145, resolution number 10. Now, this is relevant to the case of the petitioner. So allow me to just read out this. Resolution number 10. Representation by Sri so-and-so accountant. He was an accountant for promotion. The board noted that the representation has been submitted by Sri so-and-so accountant requesting for promotion to the next higher post, assistant manager in the accounts and finance cadre. You also may also note that again, the cadre which has been used by the board itself. The board noted that unless a vacancy arises or creation of a new post, simply having completed the eligibility length of service for consideration of promotion does not confer any right on an incumbent to be promoted to the next higher rank. However, without any prejudice to the present case, the board was unanimously of the view that since restructuring of corporation is being taken up shortly, all such matters be taken up only after the necessary restructuring and downsizing, if any, is completed. This same finding of the board was applied to the case of the petitioner at page 146, resolution 11. She also submitted a representation for promotion, but the board noted that a representation has been submitted by Ms. So-and-so, requesting for promotion to the next higher post, that is deputy manager in the legal service cadre. The board maintained that its views as in item 177.10 would apply to the present case also. So the same finding was applied to the case of the petitioner. Now thereafter, at page 147, sorry.
Page?
147. Now this has already been alluded to by the petitioner. Pursuant to the decision of the board to go for regularization of the ad hoc officers and staffs, this was issued. Suitability test, the typed copy is at page 147, 48. The married, page 148.
Suitability test.
Yes,
Sweet.
page 148. That's a subject matter. With reference to the above subject and in compliance with the government OM number so-and-so dated July 4, 2008, a suitability test is to be conducted under the chairmanship of the head of the administrative department and representative of PNER and ATI Kohima, including the head of concerned department. There are presently 2 assistant managers on ad hoc appointment who have already put in over 4 years of service for whom the suitability test is to be conducted. You may therefore propose to the administrative head of the department for fixing a convenient date for the suitability test and intimate to this office for further necessary action and information of the concerned department. Now, pursuant to this, the process for regularizing the respondent number 3 was carried out. Now, in this regard, the NIDC is also not a government department. It's a company created under the Companies Act. Even though it's a government-owned company, it is not a government department. Yet, the board, in its wisdom, decided that as a matter of propriety, this be followed. The policy of the state government then existing was that whoever has served 3 years on continuous service on contract basis be regularized. Now it was on the basis of this that the respondent number 3 was regularized in a post of assistant manager at page 151. Before the respondent number 3, before he competed for as a fresh candidate to the post of deputy manager, the board in its at page 153, this is the 182nd meeting of the BOD held on April 20, 2011. Again, another cadre review was proposed at page 154. I will not be reading out, but the proposal for cadre review of employees. resolution 7. 154 resolution 7. Yes. Subsequently, this led to the current service rule, which is standing as of today. That is a 2016 service rule, which I will later on refer to. Now, after this, at page 156, the respondent number 3, page 156. Respondent 3, as assistant manager, submitted his an application to the MD and IDC to compete for the post of deputy manager as a fresh candidate. Now, in this regard, since this has already been read out, but just would like to refer to paragraph 3. Reference was made by the respondent 3 to the ratio of 50-50%, 50-50 for promotees and direct recruits. Now, this is based on a 2001 amendment of the service rules. Just that point. Subsequently, as already alluded to by the petitioner, at page 159, circular was issued calling for the interview, and then at page 160. This was called by the Departmental Promotion Committee for consideration of promotion of the officers of NIDC held on 26th July 2012. Now, the relevant clause is at clause 4. Insofar as the post of deputy manager is concerned. Allow me to read it. The committee noted that for the post of deputy manager, the ratio of appointment by direct recruitment and promotion was 50-50. The committee was surprised that presently, out of the existing 5 posts of deputy managers, only 1 post is being held by a direct appointee and the remaining 4 posts by promotion. The committee was surprised that on the basis of a representation submitted by Sri so-and-so, assistant manager, that is the respondent 3, to allow him to appear for the written test and interview as he possessed the necessary qualifications and work experience, the management had allowed him as an in-service candidate, despite not having completed the minimum years of service, to be eligible for promotion to the post of deputy manager. Next paragraph. The committee noted that, as in the case of manager and IDC, had conducted a written test of eligible officers for the post of deputy manager. The committee noted that 3 officers who were eligible for promotion and 1 officer as an in-service candidate, having the requisite qualification for direct recruitment, have undertaken the written test. Now, this pertains to the petitioner as well as 3 others. The committee thereafter conducted oral interview of the officers and assessed them on the basis of the following criteria: aptitude, B, personality, C, knowledge, and D, experience. The committee gave markings on a scale of 10 for each of the above criteria. The committee further added the grading scored in the ACRs of each of the officers and the marks secured in the written test. Recommendation. On the basis of the marks scored in the written test, oral interview, and ACR grading, the committee recommends the appointment of the respondent 3 to the post of deputy manager as an in-service candidate to be taken as a direct recruitment. Now again, the appointment to the post of deputy manager was in the management service cadre, for which a specific educational qualification has already been prescribed in the service rules of 2001. The petitioner does not possess this, and in addition to this, the Lordship has seen that there are 3 officers and the respondent 3. If at all anybody is aggrieved, it is these 3 officers who ought to have challenged the appointment of this respondent 3. But they never did. Nobody challenged the appointment of the respondent 3. Although these were the 3 officers, although the names have not been mentioned, these were the persons who were in the zone of consideration for being promoted to the post of deputy manager.
But why by the DPC and not by a selection board?
Yes. Now, here it was by the DPC, but if your Lordship may also have clause 5, what the DPC did in respect of the petitioner, post of deputy manager legal. The committee noted that Ms. So-and-so, assistant manager legal, has been looking after the legal department of the corporation single-handedly following the deputation of the manager legal to NPSC. The committee further noted that MS so-and-so, having an LLB degree, has been competently discharging the duties and has been in the same position for over 11 years, and as such, if found suitable by the DPC, the management proposed to upgrade the post of Assistant Manager Legal to Deputy Manager Legal, and the incumbent be promoted to the upgraded post. The committee noted that there were no adverse remarks in the incumbent service record, and the ACRs have been highly graded. Now, in this regard, the submission is that the DPC will not have any authority in respect of other departments, government departments, will not have any authority to upgrade a post. It cannot do. If you are to go by the strict terms of the manner in which the other departments function. Now, NIDC is not a government department. The PC, in its wisdom, found it fit to upgrade the post and to promote her. Now, whether the DPC can have the authority to upgrade a post, it has to be undertaken by a cadre review committee, or in the other cases, we have a manpower or rationalization committee. But the NIDC service rules being administrative in nature, by doing this, no right of the petitioner has been violated. In view of the fact that she has no locus standi, she has no education qualification, she does not belong to the same cadre as that of the respondent 3. Therefore, she is not an aggrieved person to be raising the grievance that has been raised in the petition insofar as the appointment or the regularization of the respondent 3 is concerned. Now, that is the contention which is being advanced by the respondent 1 and 2. And the court may not dwell as to whether the legality, as to whether the DPC could have done this or that. The DPC could not have, at the course of repetition, as to how the other government departments function, the DPC could not have upgraded the post. But both these actions of the DPC were subsequently approved by the BOD at page 163 in its 185th meeting. Resolution 8. Resolution 8 at page 164. The board considered the recommendations of the DPC.
Yes.
And I will not be reading out, but the findings is here. And the petitioner in the next page, 165, sorry, at 165 is serial number 4 is +4, sorry, is the respondent 3. And the next paragraph pertains to the petitioner. Now, the board, in its wisdom, decided to approve the recommendation of the DPC, even though admittedly, it may not have been done strictly in accordance with the service rules, but the service rule being administrative in nature, the board's competence, in my humble submission, the board's competence is what matters. Thereafter, the subsequent orders were issued. Now, the next aspect is the page 168, where the board approved another amendment of the NIDC service rules. Page 168, this is the 194th meeting of the BOD dated 15 June 2017. The relevant resolution is resolution number 5 at page 169.
Further review.
Yes. And the promotional channel, which we are concerned with in this petition, is at page 172. Now, this time, the board decided to add another cadre or stream to its service. A is the NIDC subordinated service staff service rules, service. B is the NIDC ministerial service. C, a new service, NIDC IT service. D is the NIDC legal service. E the NIDC Management Service, and F, the NIDC Account Service. Now, these are the streams and or the cadres in the service rules as per the 2016 rules. Now, in this, Lordship may note that this time the legal service and the accounts service, they have been given the opportunity to reach the post, the highest post, that is MD. The convergence, this is the dispute. The convergence is at DGM. Next is GM and MD. And again, in the same manner as has been done in the 2001 amendment, in a note as appended 1, the promotion of employees shall be considered on the basis of the respective service / cadre / stream only till it reaches convergence level. And then it specifies the educational qualifications. Now, in view of the this separate cadre or streams being maintained by the NIDC in its service rules, the contention of the petitioner is to the effect that she is senior to the petitioner will not have any bearing or relevance because the cadres or the streams are separate. Only when it reaches the convergence level, now the dispute will start as to who the TPC finds it fit to promote. The seniority in the legal service, even though the NIDC has maintained a common seniority list for all its officers and staffs, in view of this separate cadre and stream being maintained, the interstate seniority, it will not have any bearing from one service as relative to another service. Now that is the contention I'm advancing, and in regard to this, I will allow me to place certain authorities, but later on, I think. Allow me to conclude the second limb of my submission with that on the local standing of the petitioners to challenge the appointment of the respondent number 3. Now, in this regard, I have certain authorities. Serial number 5. Flag serial number 5. Flag 5. This is for the proposition that the petitioner has no locus to challenge the appointment and or regularization of the respondent 3. The first is 2006-11 SCC 731. Just one paragraph. Paragraph 78.
78.
78.
Yes.
The High Court in the instant case was not exercising certiorari jurisdiction. Certiorari jurisdiction can be exercised only at the instance of a person who is qualified to the post and who is a candidate for the post. This court in Umakan Sarant versus State of Bihar held that the appointment cannot be challenged by one who himself is not qualified to be appointed. In Kumari Chitra Ghosh versus Union of India, a constitution bench of this court held this under. The other question which was canvassed before the High Court and which has been pressed before us relates to the merits of the nominations made to the reserved seats. It seems to us that the appellants do not have any right to challenge the nominations made by the central government. They do not compete for the reserved seats and have no local standing in the matter of nomination to such seats. The assumption that if nominations to reserved seats are not in accordance with the rules, all such seats as have not been properly filled up would be thrown open to the general pool is wholly unfounded. Now, this is the argument of the petitioner, that it has not been carried out in accordance with the NIDC service rule, therefore it has to be thrown out. But when in the first place, she has no local standing to raise any grievance as regard the appointment of the petitioner, because she does not possess the requisite qualification of the respondent of 3, that is the management service cadre. Both of them belong to the separate streams of service. Now, therefore, the question as to whether the NIDC service rule has been violated or it has not been adhered to will not be relevant because of the lack of local standing of the petition to raise such a grievance. The second authority is our division bench of this serial number 6, 2006, 4GLT 503, division bench of one High Court. Again, on the concept of the person, on a aggrieved person, paragraph 7 and 8. 7. The order of appointment of a person against a post can be challenged by a person who can claim appointment against a said post. A person who is not qualified to be appointed and who did not apply for the post cannot challenge the appointment of a person against the said post. The person who challenges an order of appointment of another person by filing a writ petition must therefore be a person aggrieved by such appointment. 8. A person can be said to be a person aggrieved by the action of the government in appointing another person in a post if that action deprives that other person from his right to be considered for appointment against the said post. The petitioners to maintain a writ petition challenging an appointment of another person must show what legal right of theirs has been violated by the action of the respondent in making such appointment. A person aggrieved is a person who has a genuine grievance against an order which has prejudicially affected his rights and interests. This is the relevant portion. A person who is not directly and immediately affected by an order of appointment, but remotely affected, or his chances of promotion in future has been affected by such appointment, cannot maintain a writ petition challenging the appointment of another person. As such person cannot be termed as person aggrieved to maintain such writ petition. The jurisdiction of the writ court being equitable and discretionary, it will not issue any writ quashing the appointment of a person on the basis of the writ petition filed by a person in whose favor no relief can be granted. The petitioner's primary grievance being the seniority. This court may not dwell on the question of appointment in view of the fact that at the course of a petition, the petitioner does not have the locus to challenge the appointment of the order of regularization, the respondent number 3. Now the third authority is 2020-12 SCC 87, that will be serial number 7. Even though the petitioner has raised or questioned the appointment of the respondent 3 after quite a considerable lapse of time, yet even though the question of going back as to at that time of appointment, what was the service rules? What was the service rules operating? The court has to go back to that date. So in this regard, paragraph 23, 24, 25, I'm relying on. More or less the same principle, so I'll just read out 24 and 25. The specific case set up by Noida in its counter affidavit is that appellant 1 was appointed as junior engineer in 1987 and was promoted to the post of assistant project engineer on 27/8/2013. Thus, he lacks necessary qualification of 8 years experience and shall be eligible for being considered for appointment in 2021. Insofar as appellant 2 is concerned, he was appointed on the post of assistant project engineer in February 2009. As prescribed by the service regulations, he became eligible for being considered for promotion in completing 8 years of service in February 2017. Thus, at the time of appointment of respondent 4 in 2014 and his subsequent absorption in 2015, both the appellants were not eligible for promotion to the post of project engineer for want of requisite 8 years experience as assistant project engineer. 25. For the aforesaid facts and reasons, the challenge made by the appellant to the appointment and absorption of respondent 4 is not tenable, and they have no local standing in the matter. Now again, thereafter, principle of the person aggrieved was stated by the court. Now, secondly, on the aspect of interstate seniority and the lack of any standing on the petitioner to challenge the appointment or the regularization of the respondent on the basis, on the presumption that in view of a common seniority list, she is senior to the petitioner. No doubt she is senior in the common seniority list. But in view of the separate cadres or streams being maintained, this common seniority list will lose its relevance. Now, in this regard, I'm relying.
Then in that case, from manager to DGM, what is your criteria for promotion?
Yes, at the convergence.
Yes, at the convergence. At the convergence.
It will be Rule 29, which will be my third and final limb of submission. Allow me to just complete this. Now, serial 8, flag 8.
Yes.
AIR 1963. Paragraph 24. Just half of the paragraph. Paragraph 24. As we have already stated, the two services started as independent services. The qualifications prescribed for entry into each were different, The method of recruitment and the machinery for the same were also different, and the general qualifications possessed by and large by the members of each class being different, they started as two distinct classes. If the government order of September so did not integrate them into a single service, it would follow that the two remained as they started as two distinct services. If they were distinct services, there was no question of interstate seniority between members of the two services. That's all. And therefore, even though a common seniority list was maintained by the NIDC, it has no bearing insofar as the petitioner's claim to be promoted on the basis of such seniority list is concerned. Okay, now on my final limb of submission on the convergence to the post of DGM. Rule 29, if I may be allowed to read that concerned rule. Rule 29, page 72, sorry, page 72. This is the promotion. For all category of posts, it says, for all category of posts, the basic criteria for promotion would be merit, suitability, efficiency, and past performance with due consideration of seniority. Now, therefore, it is clear that the consideration for promotion is merit cum seniority, not seniority cum merit. Now, again, continuing with the Rule 29, the minimum service in the lower post required for promotion to the next post shall be as indicated in the Annexure 1. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance appraisals, interview, or written test, and also by assessing regular work. The appointing authority shall be competent to promote the DPC, the employees through a DPC constituted by board in case of officers and by many, so and so and so. Now, the other rule which we're concerned with is Rule 28, prescribing as to how seniority is to be maintained. Rule 28, page 71. Yes. This rule has different aspects to it. And the first is seniority of person appointed to a grade shall be determined in the class of post to which they are appointed by the date of joining of their post. Now, this is one aspect. The second aspect is the interstate seniority. The interstate seniority of the persons promoted from lower grade shall be maintained in higher grade as well, except in the case of superstition. Now, this portion of the Rule 28 has to be read with Rule 29, because Rule 29 prescribes all categories of posts to be selection posts. That is the contention which I'm advancing. It says all category of posts. For promotion to all category of posts, the principle is merit cum seniority. Therefore, when it comes to the principle of merit cum seniority, seniority does not find the first place. It's always merit. And how to assess the merit, the Rule 29 has provided. The criteria to determine merit, suitability, and efficiency should be on the basis of performance, appraisals, interview, or written tests, and also by assessing regular work. This is how it is to be assessed. Only when, in the principle of merit cum seniority, only when the seniority are more or less equal or roughly equal, that is where, only when the merits are equal or more roughly equal, that is where the seniority will come in. That is the principle, that is a settled principle. And my submission is that this interstate seniority aspect, as mentioned in Rule 28, has to be understood in that context as read with Rule 29. Because simply saying that the interstate seniority of the persons promoted from lower grade to be maintained will, if we are to go with that, that will be violative of Rule 29. If seniority alone is to determine in matters of promotion. Now, keeping the two rules in mind, the meeting minutes of the DPC If your lordship may come now to page 177. This was how the first DPC was held, followed by the second DPC.
Page one
Yes,
seventy-seven.
page 177. This, we are concerned here with the convergence, which is at close to Deputy General Manager. We have 3 posts. Now, in accordance with Rule 29, the DPC was held on August 17, 2020. Now, if your lordship may have paragraph, just that paragraph above clause 1, General Manager, 1 post. Yes. The committee, after perusal, of all the available records of the officers in line for promotion, had considered and recommended the following cases against the various categories of vacancies based on merit cum seniority and past performance of duties, which are as below. Based on this, now the in the post of Deputy General Manager, the respondent 3 was placed at clause 1, serial number 1. The petitioner at 2, and 3 were not considered. Now, based on this, on the recommendation of the DPC, the NIDC, they issued a seniority list. In the, if your lordship may have the main petition, page 84. Page 84, the relevant list is at page 85, where the respondent is at serial number 4 in the rank of DGM, and the petitioner is at serial number 5. Subsequently, that the petitioner addressed a representation to the MD. Now, the MD unilaterally, without any authority, he issued another seniority list, placing the petitioner above the respondent number 3. Now, in that regard, I have clarified in my affidavit that this was a mistake. This was not found in the service rule, because
This January 21st, 2021 seniority list was issued after the DPC of
yes,
17
DPC of 17 August 2020.
Then after that,
And after that, the petitioner addressed a representation. And which is at page 98, and I've already read out. Whereafter, the office order at page 100 was issued. And this was issued by the MD. There was no consultation with the board. Thereafter, at page 101, the petitioner has been placed at serial number 4, and the respondent number 3 has been placed at serial number 5. Now, in the affidavit of the respondent 1 and 2, we have stated at paragraph 35, page 26 of my affidavit. We have stated that paragraph 35. As regard the statements, these are the relevant statements made in paragraph 5.1 and 5.2. It is respectfully stated that the seniority list as on 31 March 2021 was mistakenly issued in contrary to the recommendation of the DPC meeting dated 17 August 2020, where the select list was prepared. Now, why we have stated this is because in the when it comes to the principle of merit cum seniority, it is the DPC who always recommends the placement of seniority as to how they are going to be adjusted in the seniority. Now, therefore, the MD had no authority to have issued such the subsequent order unilaterally without any recommendation by the DPC. Now, it was in this manner the respondent 3 was placed above the petitioner when they were promoted to the post of DGM. Now, on the next aspect is the promotion to the post of GM at page 183. This is the recommendation of the DPC held on March 10, 2023.
Page 183.
183. 183. My affidavit. Okay. Here also the DPC has taken note of Rule 29 at the bottom of the page, reiterating that Rule 29 of the NIDC service rules provides that the criteria for promotion for all category of posts, the basic criteria for promotion will be merit, suitability, efficiency, and past performance with due consideration to seniority. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance appraisals, interview, or written test, and also by assessing regular work. The appointing authority shall be competent to promote these employees to a DPC. Now, next page, 184. The committee members observed that the senior-most DGM, Sri Mentang Gap Rema, did not turn up for the DPC. His absence for the DPC was viewed seriously by the committee members with a negative remark for his next promotion. And thus, as per the assessment of the APAR, which was taken note of by the DPC, if your lordship make any note, and the performance of the officers in the interview, the committee also on examination of all the available records of the officers in line for promotion had considered and recommended the following cases against the various categories of vacancies based on merit cum seniority and past performance of duties. Now, this is the consideration of the DPC. Now, the petitioner, despite having challenged the DPC, the petitioner's contention is that seniority, that the interstate seniority maintained. But the petitioner in doing that is not challenging Rule 29 of the NIDC service rules. If at all she was aggrieved. Rule 29 specifically prescribes that all posts will be selection posts. Selection posts meaning that for the purpose of promotion, there will be a method of selection to determine as to who is meritorious to be promoted to the next post. The entire contention of the petitioner relies on the interstate seniority that has to be maintained. But Rule 29, this is what the rule provides. The DPC has considered the APAR, the performance of the officers, how they're performing the duties. Now, these are relative matters between, insofar as the petitioner and the respondent is concerned. Now, it is a settled law that this court in its jurisdiction does not enter into the relative comparison of merits done by the DPC. Now, therefore, in the absence of any challenge to Rule 29 made by the petitioners, and in the absence, in my humble submission, the DPC, while conducting their meeting for promoting the petitioner as well as the respondent, has not violated Rule 29. In fact, it has strictly adhered to the provisions of Rule 29, how it has been prescribed. Now, Rule 29 does not prescribe how to assess merit, how points are to be given. It does not. But they have considered the APAR, interview, the past performance, their performance in the offices. Now, these are subjective matters which has been duly considered by the DPC. Therefore, it is a submission of the state respondents that the challenge led to the findings of the DPC as well as the subsequent arrangement of seniority does not suffer from any arbitrariness. Now, in this manner, at clause 1, general manager, the respondent number 3 has been placed at serial number 1, petitioner at serial number 2. And this is the recommendation of the DPC. Subsequently, issued the notification was issued wherein the respondent 3 is senior. Now, again, this aligns with the preamble of the NIDC because of the fact that the NIDC is a corporation to be guided on business lines. The consideration of the DPC does not warrant any interference insofar as the findings and its adherence to Rule 29 is concerned. Now, even though the petitioner has made certain statements regarding malafide. Now, which is also a ground to assail the DPC. There is nobody has been in person has been impleted. The members of the DPC has not been impleted in the personal capacity. Malafide, again, it has to be proved. No material has been substantiated or produced by the petitioners to show what kind of malafide has been done on the petitioner. Now, the final aspect of the matter, since the petitioner, sorry. The petitioner has relied at page, which may come to page 100. Yes, 193. The petitioner relies on a past action of the board of directors, wherein even after the DPC had recommended the placement of seniority or the placement of the concerned officers there at this point of time in 2004, the board has issued an order rectifying such placement. Now, this has been relied by the petitioner. The relevant resolution is at page 194, resolution number 7. Now, I'll not be going through the entire content of this resolution, but I've already stated in my affidavit that this concerned deputy general managers, they belong to the same stream. That is the management service. They belong to the same stream. Now, therefore, this finding may not be relied upon by the petitioner or may not benefit the petitioner insofar as and this was done in 2004 on March 10, 2004, when the 2001 service rule was in operation. And at that point of time, at page 137 again.
So you mean to say that this Mr. Imsi Jamir,
Mhm.
he was from the management cadre?
Yes, both retired as MDs.
Yes. Page?
At page 137. Now this, when the board took this decision in 2004, we have the 2001 service rule which is in operation. And at this point of time, the legal service, as I had already pointed out earlier, but just for the court's attention, the NIDC legal service can, their promotion scope is still the post of manager, legal service. Yes. Now, in order to buttress my submissions again regarding the findings of the DPC, the placement of the respondent tree above the petitioner, I would just like to rely on certain authorities. Starting from flag 11. Now, since Rule 21 says in its starting line for all category of posts, therefore all these posts are selection posts. Now, what is this selection post? This principle of selection posts, I'm relying on this, the first 2001 5 SCC 60, paragraph 6, 7, 8, 9, and 10. Just for my own benefit.
No, your serial number 11.
Sorry, serial number 11, yes. On the meaning of selection post.
2006 SCC 698.
Yes.
Para?
Paragraph 6 to 10. Short paragraphs. The principle of merit cum seniority is an approved method of selection, and this court in so and so held that promotion to selection grade posts is not automatic on the basis of ranking in the gradation list, and the promotion is primarily based on merit and not on seniority alone. At page 1914 of the judgment, it is stated as under. The circumstance that these posts are classed as selection grade posts itself suggests that promotion to this post is not automatic, being made only on the basis of ranking in a gradation list, but the question of respondents, but, sorry, but the question of merit enters in promotion to selection posts. In our opinion, the respondents are right in their contention that the ranking or position in the gradation list does not confer any right on the petitioner to be promoted to selection posts, and that it is a well-settled established rule that promotion to selection grades or selection posts is to be based primarily on merit and not on seniority alone. The principle is that when the claims of officers to selection posts is under consideration, seniority should not be regarded except where the merit of the officers is judged to be equal and no other criterion is therefore available. 7. The court further held that such mode of selection is not violative of Article 14 of the Constitution. 8. In so and so, the Constitution bench of this court held that the promotion to selection posts is not a matter of right which can be claimed merely by seniority. And 9, in so and so, it was held as under for inclusion in the list, merit and suitability in all respects should be the governing consideration, and that seniority should play only a secondary role. It is only when merit and suitability are roughly equal that seniority will be a determining factor, or if it is not fairly possible to make an assessment inter se of this merit and suitability of two eligible candidates and come to a firm conclusion, seniority would tilt the scale. In so and so, 10. This court held that the principle of merit cum seniority lays greater emphasis on merit and ability, and seniority plays a less significant role. Seniority is to be given weight only when merit and ability are approximately equal. Now, the next authority is the same serial number 9, the flag number 9, 2001-5 SCC 60.
Flag number?
Flag 9. Now, these are, I'm relying on this authority again because the petitioner has advanced a contention to the effect that they are competing for two posts. Therefore, the question of assessing relative merit for the two posts cannot happen. Now, in this case, amongst others, seem to have misplaced it. I'm relying on paragraph 2, 12, and 14. In this case,
This is 2001, 5 ACC 60.
Yes, Your Lordship. Paragraph 2, 12, and 14. The facts I've already relied on earlier. Now, in this case, what has happened was the petitioner was placed below his juniors. She filed a writ petition. Now, the principle of merit cum seniority applied. They were competing for more than 15 posts. Insofar as can be ascertained from the SEC records, it was 15 posts. They were competing for 15 posts. The Supreme Court says there's nothing wrong to place the petitioner below his juniors in view of the fact that the determination was done, the determination for promotion was done by principle of the merit cum seniority. Now, therefore, there is no question of anything wrong being done in assessing the relative merit of the petitioner and the respondent in this case, even though there may be two posts. The relative merits can be assessed, even in this case also. For that only, I'm relying on this 2001-5 SCC 60. Now, the next authority is on the role of courts with regard to the proceedings of DPC, flag number 12. First, flag number 12, 1991 SEC 305. This one paragraph is paragraph 12.
It will thus appear.
Yes, it will thus appear that apart from the fact that the High Court has rolled the cases of the two appointees in one, though their appointments are not assailable on the same grounds, the court has also found it necessary to sit in appeal over the decision of the selection committee and to embark upon deciding the relative merits of the candidates. It is needless to emphasize that it is not a function of the court to hear appeals over the decision of the selection committee and to scrutinize the relative merits of the candidates. Whether a candidate is fit for a particular post or not has to be decided by the duly constituted selection committee, which has the expertise on the subject. The court has no such expertise. The decision of the selection committee can be interfered These are the grounds with only on limited grounds such as illegality or patent material irregularity in the constitution of the committee or its procedure, vitiating the selection or proved malafide affecting the selection, etc. It is not disputed that so and so says. In view of the sorry. Allow me to just continue, sorry. It is not disputed that in the present case, the university had constituted the committee in due compliance with the relevant statutes. The committee consisted of experts and it selected the candidates after going through all the relevant material before it. In sitting an appeal over the selection so made and in setting it aside on the ground of the so-called comparative merits of the candidates as assessed by the court, the High Court went wrong and exceeded its jurisdiction. On similar principles, allow me to just rely on one more authority, the flag number 13, 2007, 14 SEC. Paragraph 27. Paragraph 27 reads, in our opinion, the judgment of the tribunal does not call for any interference inasmuch as it followed the well-settled dictum of service jurisprudence that there will ordinarily be no interference by the courts of law in the proceedings and recommendations of DPC unless such DPC meetings are held illegally or in gross violation of the rules or there is a misgrading of confidential reports. In the present case, DPC had made an overall assessment of all the relevant confidential reports of the eligible officers who were being considered. DPC considered the remarks of the reviewing officer, there was clear application of mine. Respondent 1 did fulfill the benchmark. Hence, the impugned direction of the High Court ought not to have been issued, as the same will have the impact of causing utter confusion and chaos in the cadre of the Indian Revenue Service and the Customs and Central Excise Service. So that being the principle, I'm submitting the intention that the findings of the DPC as impugned in this petition warrants no interference in view of the fact that we have clearly followed the rules as has been laid down in the service rules. Just two more authorities. Now, this contention has not been advanced by the petitioner, but just for my own benefit, I would like to rely on these two authorities. Flag number 14, 1995, 3 SEC 383. Paragraph 18 only. Paragraph 18. Three so and so, then relied upon the decision in so and so in support of his submission that administrative orders affecting the rights of citizens should contain reasons therefore. We are afraid the said principle cannot be extended to matters of selection. Unless the rules require, the selection committee / selection board is not obliged to record reasons why they are not selecting a particular person and or why they are selecting a particular person, as the case may be. If the said decision is sought to be relied upon with respect to the adverse remarks made against the appellant, the attack should fail for the reason that the memo containing adverse remarks in the case does set out the particulars in support of the same. It is equally relevant to note that no allegation of malafide or arbitrariness has been leveled against the chief of the army staff who made the said remarks. In view of in case, just for my own benefit, I would like to, I'm relying on this, to say that the DPC did not record any reasons as to why they are selecting respondent 3 over the petitioner. The second authority on the same principle, flag 15, paragraph 7. Paragraph 7. We will first consider the second point. In the first place, it must be noted that the function of the selection committee is neither judicial nor adjudicatory. It is purely administrative. The High Court seems to be in error in stating that the selection committee ought to have given some reasons for preferring so and so as against the other candidate. The selection has been made by the assessment of relative merits of rival candidates, determined in the course of the interview of candidates possessing the required eligibility. There is no rule or regulation brought to our notice requiring the selection committee to record reasons. In the absence of any such legal requirement, the selection made without recording reasons cannot be found fault with. The High Court, in support of its reasoning, has however referred to the decision of this court in so and so. That decision proceeded on a statutory requirement. Regulation 55, which was considered in that case, required the selection committee to record its reasons for superseding a senior member in the state civil service. The decision in so and so was rendered on so and so. In June 1977, Regulation 55 was amended, deleting the requirements of the civil so and so. Now, this I will rest at that. Again, just to support my contention that the Rule 29 does not prescribe that the TPC has to record its reasons as to why it is promoting somebody over somebody. Finally, on Malafide, your lordship very well knows the settled law, but just for my own benefit, allow me to just rely on one more. Like 17, paragraph 55. Only a few lines to paragraph
This is
55.
on Malafide.
On Malafide, yes. It is a settled law that the person against whom malafide or bias was imputed should be impleaded eo nomine, that is, by that name only, as a party respondent. Oh, sorry. Paragraph 55, I'm sorry. It is a settled law that the person against whom malafide or bias was imputed should be impleaded eo nomine, that is, by that name, as a party respondent to the proceedings and given an opportunity to meet those allegations. In his or her absence, no inquiry into those allegations would be made. Otherwise, it itself is violative of the principles of natural justice as it amounts to condemning a person without an opportunity. I'm also relying on the other authority, but I will not be reading out any further. Flag 18, paragraph 16, more or less in the same line.
Let's come back at 2.
Yeah. Next week I'm not going to go. Every weekend I have to go pick up my son. Okay, some of them. Well, 15 years, no?
May please, Lordship, I'd like to mention item number 19.
It's a costly sum.
Let the matter come up on Thursday as a fixed item.
Item 19.
Yes, Lordship.
Okay, Kosa, just put it 19. Fix item.
If you oblige.
Yes,
I'm resting my submissions with that, with the contention that the
you were
petitions.
citing another authority.
Yes, but I'll not be
Yes.
reading out on the principle of mana fide. The two authorities, the last one I'm not reading on, just the
Okay.
paragraph I've already mentioned in my note.
Okay.
I'm obliged.
On to number 3.
Yes.
May I please, my lady? The counsel for the petitioner the other day had made a very extensive submissions on the facts. So to avoid repetition and to save time, I'm not going to repeat
Yes, yes.
the facts,
that's
because
okay.
by now
Mm.
I'm sure that my lady is familiar with the facts of the case. Secondly, the submission of my learned friend for respondent number 1 and 2. I'm adopting his submission. So in order to avoid repetition, can I will not repeat his submissions, because legal points, the legal issues are involved here is almost similar. But then few points I would like to point out. But then on certain issues subject to repetition, I may like to
It was mainly on locus, then the maintainability, NITC not being statutory body.
yes.
Yes. Alternative remedy.
Yes, so those issues, I may supplement with some points here and there, but then I'm adopting it because in my note, I have prepared all that for submission, but after listening to him, I thought it would not be necessary for me to repeat all that to save time. Kindly allow me to refer to the service rule once. Thereafter, I'll go to the prayer of the writ petition, then I'll make few points here and there to supplement the submission of respondent number 1 and 2. Lady, kindly allow me to refer to the service rule in the affidavit of 1 and 2, because this is more convenient, and also the memorandum of association is also enclosed. Kindly allow me to refer to the memorandum of association in page 33. I will not read, but I'll just only point out at paragraph page 37, starting from Roman 3, is the main objects to be pursued by the companies and its corporation are then up to page 30, up to page 40 are the objectives of the company in ITC. And I'll only read the first one, 34.1.3.1, to promote, establish, execute and run industries, projects and enterprises for manufacture, production, processing, refining, selling and or export of sugar beet, molasses, alcohol, liquor, yeast and other derivatives produced from sugar, such and such. Then do to promote, establish, execute and run industries, projects or enterprises for manufacture, production, selling and or export of vineyard, such and such, such and such. So it is only about industry and profit. Objective in one line, it is all about industry and profit. And my learned friend has, and page 42, the definition. 2T is the board of directors, means the board of directors of the company. Then last one, L, bylaws means bylaws which will be made by the board of directors of the company under these articles and which may for the time being be enforced. Then 31 and 32, my learned friend has gone through. So I'm not the powers of the directors. Powers of the directors is starting from page 47. I'm reading 30 at page 47. For the conduct and management of the business of company in general and subject to the control, supervision and direction of the board of directors, the company may appoint a managing director who may be a whole-time employee of the company and may be paid such salary in or allowances as may be fixed by the governor. Then powers and duties of the directors is starting on 31. Then 32 talks about power to make bylaws and so on and so forth. So the board of directors, so the plenary power lies with the board of directors. Well, all the plenary power as well as the residuary powers is with the director, board of directors. So any decision, since it is a profit-making company, and the main objective is to make profits. So any decision of the board of directors is final. Then to the service rule at page 53. My lady, may kindly allow me to read the preamble, which is at page 58. It will throw a light. Preamble of the service rule. May I?
Yes.
Whereas it is felt necessary to frame rules defining the terms and conditions of service of the employees of the NITC Limited, and whereas the corporation is an undertaking of the government of Nagaland to be run on business lines, these rules are to be interpreted, keeping in view the ultimate objective of the organization, that is, continued accelerated growth of the corporation as enumerated in the memorandum of association of the corporation, vis-a-vis the normal aspiration of the employees for career advancement. The board of directors such and such. So this is the ultimate objective is as enumerated in the memorandum of the corporation is the primary objective of this rule. Unlike a rule under 309, it is non-statutory in nature, and the ultimate object is the accelerated growth of the corporation, and of course, keeping in view the normal aspiration of the employees for career advancement. Now, statutory bodies, we all know, are created by law and are typically government run or funded. Non-statutory bodies are not mandated by law. In other words, it is not passed through a legislation in the assembly, but may still be regulated, of course. Within the smooth functioning of the company, it will be used as a regulation. Statutory rules, bodies are created by act of parliament. It has got public function. The function is public in nature, and their existence and powers are regulated by the law, enacted by the assembly. Now, non-statutory bodies are organizations that are not regulated by law, and their existence and power are not set out in any legislation. It is not a public function. Their function, their activity is not public. Their function, it is private in nature. It is private function, not public function. Now, keeping that in mind, as rightly pointed out, the rule is non-statutory rules are administrative in nature. I'm reiterating that submission. Now, keeping that in mind, kindly allow me to refer to page 59. I'll refer to some of the rules, provisions, to have a clear picture before I go to
Page 59.
Page 59 onwards, rule 3 onwards. Kindly allow me to refer to the rules. Corporation is in ITC, board means board of directors. Then G at 60 means the managing director or any officer authorized to act on his behalf by the board. Then K, services means service under corporation include the period which an employee is on duty as well as on leave duly authorized by the competent authority, but does not include any period during which an employee is absent from duty without permission or overstays her leave unless specially permitted by competent authority. Then at 62W, rule means includes rules known as Service Rule of the Nagaland Industrial Development Corporation Limited, all modifications, substitution thereof. So subsequent amendments also comes within that. Then then X 63 amendment means any amendment by way of additions, alterations, or deletion in these rules, which shall be made only under the authority of the board and shall be notified to the employee either by circulation or by publishing it in the notice board of the corporation or in any manner decided by the board. Any omission in notifying an amendment in the rules shall, however, not invalidate such amendments. My lord, kindly keep this in mind. Principle of natural justice is not strictly applied here, because if any omission in notifying an amendment of the rules shall not invalidate the amendments. So that is the nature of the rule. Then interpretation and implementation. 4, the power to interpret the rules vests in the managing director who may issue such administrative instructions as may be necessary to the carrying out the purpose of the provisions of these rules. If indeed employee feels aggrieved or as regards the interpretation and implementation of any of these rules, she shall have a right to appeal to the board, whose decision shall be final and binding on all concerned. That my learned friend has referred. Then page 65, rule 7. Appointment shall be made through one of the following: by direct recruitment, by promotion, and by deputation. My learned friend for the Council of Petitioner has been making very strong emphasis that my initial appointment is in violation of the rules. Now, appointment by accreditation or promotion by accreditation is not a part of the rule. I'll come to that. Then the recruitment from amongst the employees of the corporation by promotion shall be made if suitable candidate with requisite qualification experience are available. In case sufficient number of employees are not available for filling the post by promotion, this post may be filled by direct recruitment, deputation from any other sources. If in case of direct recruitment, if preference may be given to persons belonging to indigenous inhabitant of Nagaland. So my respectful submission, my lady, the proviso, the rule 7, the last 3 lines, in case sufficient number of employees are not available for filling the post by promotion, this post may be filled by direct recruitment deputation. So that is the reason for direct recruitment to the post of deputy manager. Then kindly allow me to refer to rule 12. The minimum qualification and experience required for direct recruitment of the employees are given us in annexure 2. Kindly refer to page 98. This is the first in 91 rules before the amendment.
The minimum qualification.
Yes, minimum qualifications. At page 98 is the annexure 2, as referred in rule 12. Assistant manager, may I?
Yes.
Should be MBA, CA, ACA, ICWA, PA, BTech from recognized university institution with requisite experience. LLB is under condition. This, my learned friend has highlighted all these issues, but now I'll later stage I'll be coming on the qualification for on the locus. So this is the in the original service rule 91, this is the basic qualification for appointment to the post of assistant manager, and LLB was not a basic qualification. Then kindly allow me to refer to page 71, seniority. Kindly allow me to read. Seniority of person appointed to a grade shall be determined in the class of post to which they are appointed by the date of joining their post. Kindly keep this in mind. Date of joining. The interstate seniority of the persons promoted from lower grade shall be maintained in higher grade as well, except in case of superstition. Interstate seniority between direct recruit and departmental promotee appointed on same day in a particular post shall be 60% and 40%. So 40% respectively, direct recruitment being given precedence over departmental promotees when such a situation arises. In case 2 or more persons appointed directly on the same day in the same class, category, or grade, seniority shall be determined by merit only. So for the purpose of seniority, fixing seniority, direct recruit 60%, for promotee is 40%. And for direct recruits appointed on the same day 2 or more persons by merit only. Also, the interstate seniority of persons promoted from lower grade shall be maintained in the higher grade as well. I'll be referring to this point, because strong reliance has been placed by my learned friend that she is senior all along, and the seniority in the lower grade should be maintained in the higher grade. I'll be coming to that point later stage.
Then promotion. For all category of posts, the basic criteria for promotion will be merit, suitability, efficiency, and past performance with due consideration to seniority. The minimum service in the lower posts required for promotion to the next post shall be as indicated in Annexure 1. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance appraisals, interview, or written tests, and also by assessing regular work. The appointing authority shall be competent to promote its employees through a DPC constituted by the board in case of officers and by managing director in case of others. So for promotion, it is through a DPC. Last 3 lines.
And merit comes seniority.
And merit comes seniority. My lady may kindly appreciate the fact that Rule 29 does not provide for the DPC to give reasons. Because the other day, my learned friend also has relied on the judgment. I will be reiterating the judgment also. The judgment of the honorable courts says that unless and until the rule provides that reason should be given by the TPC, it is not necessary for the DPC to give reasons, and the fact that reasons is not given cannot be a ground to interfere. Now, thereafter, the 71, page 96.
96.
Page 96, Rule 71, last amendment.
Amendment.
The managing board shall determine any rule subject not governed by these rules on their merit. Unlike other rules, the residuary power lies with the board. So in case of any areas not covered by the rules, the board is empowered to exercise. The board management shall determine any rules subject not covered by these rules on their merit. So my respectful submission, the plenary power lies with the board. The residuary power lies with the board. So it is administrative in nature. Now, kindly allow me to refer Rule 20, page 69. An employee shall retire at the age prescribed by the state government from time to time and attaining the age of superannuation, an employee shall be retired from the service. So for purpose of superannuation, the state the NIDC under Rule 20 has adopted the procedures and criteria of the state. That's how 35 years or 60 years of whichever is earlier, and the past service, if somebody is serving on contract or ad hoc and subsequently regularized, then the past service to be counted for the purpose of 35 years of service. So that this is being followed. Exactly that is what has been done in the present case also, I will be highlighting. So keeping that, thereafter, kindly allow me also to refer to the page 102. Merit. The consequent to approval of the recommendation of the Cater Review Organization Committee by the Board of Directors on 15 June 2017, various categories of post vice versa sanction strain, promotional channel, minimum educational qualification for various posts in the corporation and minimum span of service to be eligible for promotion shall be furnished in Annexure 1, 2, 3, 4 attached to this notification. These changes come into force from the date of board's approval, that is 15 June 2017.
So the amendment to the rule, 2016 amendment to the rules came into effect with effect from 15 June 2017. My lady may kindly take note of this fact because promotion of the petitioners and the respondent to the post of Deputy General Manager and General Manager is after the amendment of the rules. So this amendment rule was holding the field when you were promoted to the post of AG, Assistant Deputy General Manager and General Manager, the effective date. Then, subject to repetition at 104, the separate streams has been provided. So I'm not, but then I'm kindly allow me to reiterate the notes. Promotion of employees shall be considered on the basis of your respective service cadre stream till it reaches convergence level. Requisite qualification for promotion to the post of manager or its equivalent post shall be graded to any discipline. This supersedes all earlier decision and orders in this regards. My respectful submission on this, we have to examine the rules. Prior to the amendment of the rules, by the notification dated 19 September 2016 with effect from 15 June 2017 and post 15/6/2017, and especially Rule 28 and 29 has to be read in the light of the amendment, because Rule 28/29 was included in the original rule of 1991 when there was no separate stream. So it was quite natural that the seniority in the law, since they all belong to one stream, it was quite natural that seniority in the lower grade would be considered maintaining the higher grade because they belong to one stream in terms of till the 91 rules. So there was no problem. But after the amendment, with effect from 15 June 2017, there is a total shift in the rule. The whole dimension has changed. So my respectful submission, Rule 28 and 29 has to be interpreted in the light of the amendment of the rules by notification dated 19 September 2016 with effect from 15/6/2017. In my respectful submission, with regard to rule maintenance of seniority in terms of Rule 28, if it belongs to the same stream, obviously the seniority in the lower grade will be maintained in the higher grade. However, beyond the post of deputy GM, if it belongs to a different stream, then in that kind of a situation, my respectful submission is that until the merit is same, Rule 29 will not be applicable for future promotion from deputy GM to GM. Because they belong to different streams. So even if a single seniority list has been maintained all along, the fact that there is a total, that everything has been changed by the amendment whereby convergence level is at the,
Is a DGM.
yes. So beyond promotion to the post of DGM, deputy GM, if where's the question of maintaining single seniority list when they belong to different streams? And most of the seniority lists which has been referred by my learned friend,
But they've been maintaining a common one.
that is what I'm saying, because all this common seniority list was prior, most of it were prior to amendment of the rules. And it is probable that after the amendment of the rule also, that must have been done. That is why I'll show you from the affidavit of government, respondent number 9, 1 and 2, that they have categorically admitted in their affidavit in opposition that all the seniority lists were wrongly prepared in the light of the amendment. I'll show the relevant paragraphs. So that aspect has to be given into consideration. And that is the reason my lady may kindly appreciate the fact that TPC of 2023, by which is under challenge for promotion to the post of general manager, the TPC minus clearly provides that that TPC was held only under Rule 29.
Yeah, that they have stated.
So, my lord, and it is not the prayer, nowhere in the pleadings or submission of my learned friend, though he was making a submission that seniority in the lower grade should be maintained and the seniority should be the basis. Nowhere in the pleading, in his pleadings, in the prayer, he take a ground that the TPC of 2023 was wrongly held only under Rule 29. Because when Rule 28 was not the basis for TBC of 2023, where's the question of seniority of the lower grade to be maintained? Where's the question of seniority coming into play? If the TBC was challenged, and if one of the ground was that TBC was wrongly held in violation of the rules, that the TBC was held without taking into consideration Rule 28, then the question of 28 and 29, because TBC was held only on the basis of Rule 29, not 28, and the petitioner have no grievance that 29 was, that is not a ground. That TBC was held in violation of the rules, that the TBC was held without taking into consideration Rule 29. So seniority is out of the window. I shall be coming to the TBC minus afterwards, but we have to clearly understand the rule before the amendment and after amendment, because after the amendment of the rules, it has brought a new dimension, separate streams till the grade of deputy GM, and thereafter, their convergence at the grade of deputy GM, and thereafter promotion to, and now everyone, there's a level playing field that even the petitioner and the respondent, everyone is eligible for promotion to the post of deputy, to the post of general manager, but solely on the basis of Rule 29, not 28. And the petitioner have no grievance for not taking into consideration Rule 28 in his pleading, in his submissions. That may kindly be keep in mind. Now, and subject to repetition, the preamble of the rule may kindly be considered very seriously. So that is with regard to the rules. Since much has been discussed, I'm not going much beyond that. Now, kindly allow me to refer to the prayer of to the writ petition. Page 28 to the writ petition, the prayer starts. First one is order number 23/3/2010, regularizing the service of the respondent. Number 3, as assistant manager. My lady, my respectful submission, this is only the legality of my appointment, legality of my appointment to the post of assistant manager. It is only academic in nature at the moment. Reason is, when I was serving as assistant manager, there was a circular. I applied as a fresh candidate to the post of deputy manager, and I was appointed as a fresh candidate. So after my appointment, after being declared successful as a fresh candidate to the post of deputy manager, obviously I had to resign from the post of assistant manager and join as a fresh candidate to the post of deputy manager. And it is the statement of respondent number 1 and 2 that I was appointed as a fresh departmental candidate to the post of deputy manager. So my seniority in promotion all along, which is under challenge, is on the basis of my fresh appointment as a deputy manager as a direct recruit. So in that kind of a situation, my respectful submission is that the issue of legality with regard to post of my regularization as an assistant manager is already redundant. It is only an academic exercise. But for the sake of discussion, I'm reiterating the submission of respondent number 1 and 2, under what scheme, the manner in which I was appointed as assistant manager has been highlighted. So I'm substantiating that point, but I feel that it's not necessary to examine either I survive with my post as assistant manager or I die in the post of deputy manager at the moment. Now coming to the post of deputy manager. Coming to the post of deputy manager, kindly allow me. Now, prayer number 2. I read this 2 together, then I'll make my submission. Prayer number 2, resolution 185A, insofar as it relates to promotion, appointment of the respondent number 3 to the post of deputy manager. B, order dated such and such, appointing respondent number 3 to the post of deputy manager. These are the 2 orders being challenged. My appointment as a deputy manager on 16/8/2012 and the resolution of board resolution 185/8. My Lord, may I appreciate the fact.
This is the direct recruitment.
Yes, this is the issue relating to direct recruitment. Initially, when the writ petition was filed, prayer number Roman 2 was not there in the original writ petition. Then we filed our affidavit in opposition. And one of the ground was that resolution 185/8 is not challenged. So the basic orders has not been challenged. So without the basic orders being challenged, because the appointment order at 16/8/2012 being consequential in nature, it will not survive. That was our response. Thereafter, my learned friend, this honorable court was pleased to allow the amendment of the writ petition by inserting prayer number 2, Roman 2. However, my lady Megalia, the PPC minutes was in the affidavit of respondent number 1 and 2, page 159 and 160.
The one which was read out.
Yes, just to show that 159 is a circular. I'm not going to read. And 160 is the TBC minutes, 26 July 2012, by which I was at serial number 4, at 161 by which my appointment is shown as direct recruit, and serial number 5 by which the TPC had upgraded the petitioner to the post of deputy manager. Now, in terms of Rule 29, on the recommendation of a TPC, board has to approve. That is what the condition of the provided in Rule 29, last 3 lines which I have referred to. Now here, my learned friend has been making a strong submission that the TPC, the Rule 7 does not provide for direct recruitment through a TPC. It should be a service selection board. It should be advertised. However, the TPC minus by which I was directly appointed is not challenged. This is the basic order. In fact, in my additional affidavit, after my learned friend has filed his affidavit, after my learned friend has filed his amended writ petition, I had filed my additional affidavit to additional affidavit of respondent number 3.
In opposition of respondent 3.
Yes, additional affidavit. I'll only read paragraph 3. Paragraph 2 talks paragraph 1 talks about how IA was filed and that the statements made in paragraph 25A to the writ amended writ petition.
Paragraph 3.
Yes. Are denied. The deponent humbly states that by adding paragraph 25A in prayer does not improve the claim of the petitioner. The deponent humbly states that by the circular dated 17/7/2012, the deponent was directed to attend the TPC held on 27/1/7/2012. Thereafter, the petitioner was selected for direct appointment to the post of deputy manager as clearly shown in the TPC minus the TPC held on 26/7/2012. It is also respectfully stated by the same TPC, the post held by the petitioner was also upgraded to the post of deputy manager. It is specifically stated that there is no provision in the service rule for accreditation. Therefore, by the imbued order, it is imbued POD 13/8/2012 at 185A, the recommendation of the TPC was approved. The deponent humbly states that in spite of the amendment to the writ petition, the petitioner has no grievance against the circular and the TPC, and it is not challenged before this honorable court. Well, to save time, I'm not reading. So my respectful submission was that the basic order has not been challenged. When the petitioner have no grievance against my direct recruitment through a TPC, and that is not challenged, then where's the question of challenging the promotion order and your lordship may kindly appreciate the fact that by resolution 185A, the recommendation of the TPC was approved, which is challenge in 2.
Approving this DPC.
Yes, approving this DPC. Now, Rule 29, the last 3 lines, it says that promotion should be on the basis of a recommendation of the TPC to be approved by the board. So in terms of the rule, this is the issue. Now, the point I'm making is when the petitioner has not challenged the basic order, where's the grievance? And another point is under Rule 7, accreditation is not a ground for the petitioner to be promoted to the post of deputy manager. Only 3 grounds, 3 methods: direct recruitment, promotion, deputation, not by accreditation. Now to challenge this, my initial appointment as deputy manager by the same TPC, is it not a clear situation where the kettle is claiming that the pot is black? So that aspect may kindly be taken into consideration. basic order not challenge, I'll substantiate my submission with the judgment later stage. So it is a established principle of law that when the basic order is not challenged, consequential order cannot be challenged. That is the law. Now, with regard to delay, appointment was made as early as 2012. And thereafter, I have been further promoted to manager, deputy manager, general manager, all that. So issues has been settled. Issues has been settled. Now, Honorable Supreme Court, I'll be supplying the due judgments. Honorable Supreme Court has said,
Your appointment is 2012.
yes. My respectful submission, as long if I'm able to satisfy your lordship on my appointment to the post of deputy manager, then legality of the other in the higher grade did not be
Yes, that will just follow.
just that's why I'm only concentrating on this point. Now, so Honorable Supreme Court has said that legality of an appointment cannot be challenged on the ground of delay. In an international airport case, there was a delay of 3 years in challenging the legality of the appointment, and the Honorable Supreme Court says, I'll be submitting the judgment. The Honorable Supreme Court says, after 3 years, legality cannot be challenged. And in direct constitutional, 5-bench constitutional bench judgments in direct recruit engineers case, it clearly held that settled issue cannot be unsettled. So after all these years, after I reached the grade of general manager, whether the issues settled many years ago, as early as 2012, legality can be questioned, or issues settled can be unsettled at this stage. That aspect may kindly be taken into consideration. So, and on the issue of locus, and I'm reiterating the submission of my learned friend that qualification,
Different cadres,
qualification, and Honorable Supreme Court has said that unless a person is eligible for that post, he's not an aggrieved person. So so from day one, she was not eligible to be in the management stream. So the question of locus does not arise at all. Now, my Lord, the other day, your lordship has asked a very important question. Is that whether the prayer that the petitioner, that the respondent should be kept out of the seniority list, the prayer that I should be decadred, whether it is part of the pleadings. That was the only question the lordship asked the other day. My learned friend was making a submission. I was joking with him. Unlike him, he made a submission for near 3 hours, 40 minutes. And at the end, he said he's cutting it short. So I said, 30 plus years hearing to him.
My learned friend told me that I would have sufficient time to reply today. It looks like I'm not going to get any time.
It looks like we're going tomorrow.
No. So that is
Going
one
into
aspect.
another day. Anyway.
That is because,
and my learned friend for the state also, he admits that he took the same time as me today.
Lordship, the petitioner wants to struck off my name from the rules. So I will not go to the other issues, but that is one. Now, so on that point, I will be making an answer. Now, coming to the prayer at page 29, I have referred up to the post of deputy manager. Then 3 is promoting respondent number, order dated 19/6/2017, promoting respondent number 2 to 3 to manager. Lordship, the board of directors 168 to the NITC, yeah.
Your Leadership, if I may be excused for today, I'll return tomorrow and reply. I have to go back to
I
Dimapur.
think that is better.
Yes.
Okay. Because,
He can finish his
Yes,
submissions.
yes.
okay, that'll save me the tension.
Yes, and
Okay.
reply tomorrow.
Yes, I
Fine.
have to come back.
Fine.
Much obliged.
I will quickly refer to the pages. Now, promoting respondent number 3 to manager is a point 42. Now, Lordship, may kindly allow me to refer to page 168 to the NITC affidavit.
168.
168. At 173 is the relevant portion. Now, recommendation of TPC for officers grade 194.6 on the bottom.
Yes.
Then Lordship, may kindly see at 174, the second paragraph I'm reading. The board appraised that it is last meeting held on March 29, 2017. It had considered and partially approved recommendation of the TPC, and some of the recommendation could not be implemented due to certain technicalities and non-finalization of the cadre review exercise. The TPC, in anticipation of the board approval of the cadre review committee nomenclature, had a sitting on 6 May 2017 and 9 June 2017, and finalized its recommendation, which was placed before the board. My name appears at serial number 2 in order of merit, the petitioner at serial number 5 for promotion to the manager post. Now, in the writ petition, the TPC held on 6 May 2017, 9 May, and this board meeting POD 194 is not challenged. Only the consequential order of appointment order by the consequential appointment order is challenged, but the TPC minus and the BUD has not been challenged.
This BOD of 15 June.
Yes, which has approved the TPC minutes for our promotion to the post of deputy manager. Only the consequential order is challenged after the POD. Then next one.
This is promotion to manager.
Yes. Then the next one, 4. Letter dated 1/9/2020 promoting the respondent number 3 to deputy manager, deputy general manager.
Responding to deputy general manager.
Yes. Now here, Lordship, may kindly allow me in my affidavit in opposition. That is affidavit in opposition of respondent number 3, page 246. Once I complete the prayer, Lordship, I'll go very fast because here only the issues will be, I'll be highlighting the issues.
Page
246.
Yes.
This is a TPC held on 17 August 2020. Then, Lordship, to save time, the Deputy General Manager, my name is in order of merit, I'm 1, she is 2. This is not challenge.
This is 17th August. 17 August 2020. Promotion to Deputy General Manager.
Yes, the TPC minus is not challenge. Then, in the affidavit in opposition of respondent number 1 and 2, page 188.
198 BOT 31st March 2023,
Page.
page 188. Lord,
BOT of 31st March.
yes, 198.4 will be, is the issue.
198.4.
Yes. Lordship may kindly appreciate this fact that TPC held on 17 August 2020 is for Deputy GM and 10 March 2023 is for GM. So the TPC minutes for Deputy GM and GM was approved by one,
By this.
yes, one BOT. So the order, the consequential order was challenged, but
17
The-
March 10 is your.
but the TPC minutes and the BUT has not been challenged. The next page, page 30,
This is also not challenged.
yes, only the promotion order was challenged. The TPC minutes and the BUT approval, which is the main issue, is not challenged. Then Lordship, next page. TPC minutes for 10/3/2023 is for it is for to the writ petition.
Minutes of DPC 10/3.
Yes.
23.
Now, my respectful submission, this prayer is defective. He wants to set aside the whole TPC. If my lord may see at page 110, the TPC was held under Rule 29, and besides Deputy General Manager up to the Assistant Manager post, TPC has considered. Page 110 onwards, page per annexure 26, 110 to 113 is the TPC minutes. The prayer should be
In your affidavit.
no in the writ petition.
No, the DPC.
Yes.
DPC of 10/3/23.
Yes, 110 annexure 26 to the writ petition. Lordship, may kindly
Not,
see.
not only the petitioner respondent, but many others.
Yes, so the prayer should have been only with regard to the petitioner and the respondent. But the whole TPC, he wants a caution set aside. That is not maintainable. Then, Lordship, the next prayer, letter dated promoting respondent number 3 to General Manager, fine, then notification. So here also, PUT, page 1, PUT of page 188, which was referred, not challenged. Because one PUT has approved for Deputy GM and GM. So Lordship may kindly keep that in mind also. Now, with regard to seniority list, circular dated 21/4/2023, the petitioner's prayers to set aside.
Like this seniority list, yes.
Now, kindly allow me to refer it 118 is a seniority list. Merit 21/4/2023 at page 118 to the writ petition. Kindly allow me to read the office circular. The employees seniority list with date of superannuation as on 31st March 2023 has been compiled as per records available in the respective service book and as per the recommendation of the TPC for officers in-house departmental promotion committee for staff, selection service committee for appointment of officer in-house selection service committee for appointment of non-gazetted officers. Then Lordship may kindly see from 119 to 126 is the seniority list of the whole department. And the prayers to set aside the whole seniority list. One. Also, Lordship may kindly see the next prayer B, for the last one, page 30.
direct the respondents to rectify the seniority list of 21/4/2023. His prayers to set aside in totality the seniority list of 21/4/2023 and to rectify the seniority list. Lordship, the dictionary meaning of rectify is to correct something that is wrong. It is not a prayer to delete my name from the seniority list. It is not a prayer to decater me from the seniority list. The prayer is set aside the whole seniority list, which is totally misplaced, and rectify the seniority list. That means now how to rectify, what he means by to rectify the seniority list, Lordship may kindly allow me to refer to his representations. The other day, my learned friend was making he had submitted everything except the seniority list. Now, by referring to the seniority, he referred to everything except his representation, her representations. If the representations are referred, then the whole thing will be crystal clear. To the writ petition at page 98.
The petitioner's representation.
Yes, the petitioner has submitted several representations. I'll quickly go through the contents is the same. So if I read the first representation, that may suffice. I was appointed as assistant manager in 1999 and regularized in service in the year 2001. My colleague Tom Chianger was appointed as assistant manager in 2008 and regularized in service in the year 2010. After serving for about 10 years, I was promoted as deputy manager by an order dated 16/8/2012. My aforesaid colleague had been then served for about 2 years and could not have been promoted to the post of deputy manager. It may be mentioned that in the year 2012, a selection process appears to have been conducted exclusively for him to direct recruitment to the post of deputy manager. Based on this purported selection, he was directly appointed to the post of deputy manager by an order dated 6/8/2012. It must be pointed out that my order for appointment as deputy manager also come out the same day, that is 16/8/2012, as that of my colleague, but I was issued the appointment order only on 16/7/2012, whereas my colleague was issued his order on 16/8/2012 itself for reasons unknown to me. Lordship, in my affidavit, I have made a categorical statement that I joined first. If necessary, I will refer to the relevant paragraph, and her representation training report is also through. So in the grade of deputy manager, as a direct recruit, I joined first, and she joined later. Paragraph 3 is important. In the seniority list, as on 13/12/13, 3/7/2016, and 13/11/2017, I am shown senior to my aforesaid colleague. As such, I had no cause for concern. This position was reversed in the seniority list by circular dated 21/1/2021. Lordship, as long as she was senior, she had no complaint against my appointment. That is what she's saying. Is it permissible? Paragraph 3.
And you had been already appointed in 2017.
Yes. And this is a representation of 2021, 3/12/2021. So she's saying, as long as I'm senior, everything is fine. But if I'm superseded, everything is wrong. Now, to save time, I'm not reading the paragraph 4, then the prayer is there at page 99. In the circumstances, I submit this representation to request the ITC to rectify the seniority list and correct my position therein vis-a-vis my colleagues, Mr. Tumjiang Jamir, within 15 days, which I will be compelled to seek justice through litigation. So her prayer is that seniority has to be rectified and she should be made senior. It is not the case that I should be deleted from the seniority list or my appointment is illegal. It should be quashed and set aside. I should be decadered. No. Then the next seniority list, next representation is at page 118. 116.
Yes.
This is
next
to save
28.
time at page 117. This is a representation submitted 17/4/2023. That is after our promotion to the post of general manager. That contains in all the same, to save time, I'm only reading the last line. In this circumstances, Mary, I submit this representation requesting you to review the notification dated 15/3/2023 and restore my seniority above my colleague. So the prayer is only about restoration of seniority, nothing more, nothing less. Then the last representation is at 127. This is a representation 2/5/2023.
Here also, seniority.
In these circumstances, I request NITC to correct the seniority list as on 31/3/2023 and to restore my seniority over my colleague, Tang Jianger. I hope that the issue raised in my representation are resolved so that the complication do not arise. So, Lordship, the only grievance and the consistent grievance, three representations, is seniority in the grade of Deputy General Manager and General Manager, nothing more, nothing less. So the petitioner is not expected to blow hot and cold on the same issue. To pray for, to quash and set aside my appointment orders, to delete my name from the seniority list, or to gather me from the service, was never her contention before the authority, and especially when the representations, and especially when the objection was raised, that before, without exhausting all the alternative remedies, the petitioner has approached this honorable court. So these issues may have be kept into consideration. Now, Lordship, in ITC affidavit, page 26, para 35.
Page 26.
Para 35.
Yes.
That as regard the statements in such and such, it is respectfully the seniority list as on 31/3/2021 was mistakenly issued in contrary to recommendation of TPC held on 17/8/2020, wherein the selection list was prepared. This is for promotion to the post of Deputy General Manager.
Yes, this was pointed out.
Yes, but I'm reiterating since it is important. So, my lord, on the issue of what is the actual case is about, what is the prayer of the writ petition, and what is the subject matter, I'm highlighting that point. Now, in my affidavit in opposition, I'm referring to paragraph 12, page 27.
Yes.
The deponent reiterates that he was appointed strictly in terms of the rules and the established policy decisions. As such, he is a bona fide employee of the NITC and a regular cadre officer. At no point of time, the writ petitioner had questioned or challenged the cadre legality of the respondent number 3, nor she had challenged the inclusion of respondent number 3 in the seniority list over the years. Her only claim was seniority, in which was without any legal basis. As such, there is no question to struck off the name of the respondent number 3 from the seniority list of NITC. It is humbly said that there is no illegality in the seniority list of 2023. It is further reiterated that competent authority had rightly placed a respondent number 3 above the petitioner in the grace of general manager on the basis of merit in seniority list of 21/4/2024. Now, Lordship, on the issue of the TPC 10/3/2023, 110 to the writ petition. Now, my lord, I'm Lordship has gone through it, but for my personal satisfaction, kindly allow me to read it because I would like to make certain submission, because now I'm coming to the conclusion that because ultimately this, then I'll be submitting some judgments. Mr. Such and Such, Chairperson of the TPC, occupied chair and welcome the members up to the meeting. And thereafter called the meeting in order. Mr. Such and Such, Member Secretary, TPC appraised the members of all the officers in line for promotion, which was placed before the committee against resultant vacancies. He further appraised the committee of the various vacancies at various levels of the officers' grade, where the cases for promotion put up before the TPC consists as follows. General Manager, 2 posts. Rule 29 of the service rule provides a criteria for promotion for all category of posts. The basis for criteria would be merit, suitability, officer, and past performance with due consideration to seniority. Second paragraph is also about rules, Lordship. Kindly allow me to read. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance, approvals, written or interview or written test, and also by assessing regular work. The appointing authority shall be competent to promote its employee through a TPC constituted by the board in case of officers and by managing director in case of others. The committee members observed that senior was such and such did not turn up to TPC. His absence for TPC was viewed seriously by the committee members with a negative remark for the next promotion. As per the assessments of the ABAR and performance of the officers, and in the interview with the committee, also in examination of all the available records of the officers in line for promotion, had considered and recommended the following cases against the various categories of vacancies based on merit cum seniority and past performance of duties as below. Then mentioned. Detailed reasons in my respectful submission is there, though it is not necessary, mandatory under Rule 29 to give reasons. The second paragraph at 112 is the reasons given.
Assessment of APAR performance.
Exactly. Now subject to repetition. Rule 28 was not a ground, was not the basis for TPC, and it was not the grievance of the petitioner that Rule 28 is left out. Now, Lordship, TPC can be challenged on very limited grounds. If a TPC is held in violation of the rules, that the constitution is illegal or the procedure adopted is wrong, then this honorable court have a power of judicial review. If TPC is held in as malafide, then the person alleged has to be made respondent, then that will be a ground for interference. Now, my learned friend also has been repeating and has submitted, and I'm reiterating only, Lordship, TPC is a body of experts. And it is a law that this honorable court have very limited judicial power of judicial review to review the finding of an expert committee.
Yes, yes, definitely. The court does not have the expertise.
Yes. So in that view of the matter, TPC cannot, so the Honorable Court under 226 cannot sit over the finding of an TPC as an appellate authority. The only submission of my learned friend the other day is that two posts and there is no question of determining relative merit. So the seniority should be the basis. That was the only ground. And there was no allegation that the TPC was constituted wrongly in violation of the rules. There was no allegation of malafide. Of course, a reference is made in certain paragraphs about malafide, but there are no specific allegations about malafide. So the constitution and the legality of the constitution of the TPC in terms of the rule is not challenged. Now, how the TPC in its wisdom has examined how they applied their mind in how many minutes of how many questions were asked, that is not for this Honorable Court to examine and question. The bona fide, when the bona fide is not challenged. Another important aspect of the matter is, here's a case without any complaint, the petitioner has appeared before the TPC. And after the TPC mandate has been declared, she had willingly accepted and joined the post. So after appearing before the TPC without any complaint, and after accepting her promotion, whether she can turn around and challenge the legality of the TPC. That is a legal submission to be considered. It is only a legal submission to be considered by Lordship, because there are many judgment ways says that if a person has willingly subjected to an authority, thereafter she or he cannot turn around and challenge the legality and validity of that interview report or that authority. And on that aspect, Lordship, I'm making that submission. So my respectful submission, subject to repetition, 28, since Rule 20 is not applicable in the present TPC, the question of seniority in the grade or the seniority, the question of seniority will not come into play. Another important issue is, it is not the case of the petitioner in the pleadings in his submission that her APAR is better, she is more meritorious.
That is not them.
That was not the prayer, or nor it is part of the pleading. Maybe she is indirectly conceding the fact that maybe my APAR is better. In fact, I have made a categorical submission in my affidavit in opposition that from reliable sources, I found that my APAR is better. But I'm not going into that field, area, but then it is not the claim of the petitioner that she's more meritorious. Her only claim is that she is senior. So seniority cannot be a basis for determination by the TPC. That may kindly be taken into consideration. And regarding Imsi Jamir and Polito Shohei, my learned friend has highlighted about the past precedent. So, Lordship, I'm not going into that fact. Now, Lordship, I have submitted my judgments, but to save time, because I have prepared a short note. If necessary, all my judgment, all the books are here.
It's better to refer like this, easier. Books.
Yes, books are here, but then on the paragraph, relevant paragraph, if your lordship wants desires to see, afterwards you can see, but to save time. Locus Standi, 2013 for SCCs, 465, paragraph 9 to 12, 70 to 23. Legal right means entitlement arising out of legal rules. The expression aggrieved person does not include the person who suffers from a psychological or imaginary injury. A person aggrieved must necessarily be one whose rights or interests has been adversely affected or jeopardized. If a person claiming relief is not eligible as per requirement, then he cannot be said to be a person aggrieved regarding the selection of other persons. 2014 to GLD 480, paragraph 10. It is by now a well-settled proposition of law that person lacking the requisite qualification for a post has no locus standi to assail the appointment of others. In this case, the petitioner did not possess the B.Ed degree. So the court said that since she does not possess the B.Ed degree, not eligible. Then settled issues cannot be unsettled. 1992 SCC 715, paragraph 47J, the decision dealing with important questions concerning a particular service given after careful consideration should be respected rather than scrutinized for pointing out any possible error. It is not in the interest of service to unsettle a settled position. Legality cannot be challenged due to delay. 1980 Supply SCC 449. One of the principal submissions for petitioners were that the appointment of the respondents were made at the time when there was no sanction for such posts and therefore their appointments was illegal. Other reasons were also advanced that the respondents were irregularly appointed as airport officers. We are afraid that it is rather late in the day for the petitioners to question the appointment of the respondents. The respondents were appointed in 1975 and the present writ petition was filed in 1978. We do not seem we will be justified in reopening the question of the legality of the respondents several years after their appointment. We also notice that the prayer in the writ petition also is confined primarily to the seniority list and the consequences flowing from the seniority list. Basic order, not challenge. 2010 1 SCC 417, challenging the consequential order without challenging the basic order is not permissible. Then on TPC Lordship, 2011-14 SCC 667. Moreover, the division bench was in error sitting this is spelling mistake here, sitting over the select list prepared by the selection committee as an appellate authority and rearranging the seniority list prepared by a committee of experts on the basis of its own valuation. 2008 9 SCC 242. We consider it necessary to reiterate the settled legal position that matters relating to creation and abolition of posts, formation and restructuring, structuring of cadres, prescribing the mode of recruitments and qualifications, criteria of selection, evaluation of service records of the employees falls within the exclusive domain of the employer. The power of judicial review can be exercised in such matters only if it is shown that the action of the employer is contrary to any constitutional or statutory provisions, or is patently arbitrary, or is vitiated due to malafide. The court cannot sit in appeal over the judgment of the employer. The court has no rule in determining the methodology of recruitment or laying down the criteria of selection. It is also not open to the court to make comparative evaluation of the merit of the candidates. 1993 SCC 694. It is not open to dispute that all the candidates were made aware of the procedure for promotion before they sat for the written test and before they appeared before the interview, before the TPC. Therefore, they cannot turn around and complain later when they found they were not selected. 2006-12 SCC 317. It is now more or less well settled that evaluation made by an expert committee should not be easily interfered with by the court, which does not have the necessary expertise to undertake the exercise that is necessary for such purpose. Lordship 2001-5 SCC, my friend for respondent 1 and 2 has already referred, so I'm skipping it. Then next, 1992, Supply 2 SCC 481. In the first place, it must be noted that the function of the selection committee is neither judicial nor adjudicatory. It is purely administrative. The High Court seems to be in error in stating that the selection committee ought to have given some reasons for preferring Dr. TV as against the other candidates. The selection has been made by the assessment of relative merits of rival candidates determined in the course of interview of candidates possessing the required eligibility. There is no rule or regulation brought to our notice requiring the selection committee to record reasons in the absence of any such legal requirement. The selection made without recording reasons cannot be found fault with. Seniority list. 2003-11 SSC 614, as has been really rightly pointed out by this court, the legislature or the governor of the state, as the case may be, may in its discretion bestow or divest a right of seniority. This is essentially a matter of policy, and a question of a vested right would not arise, as the state may alter or deny any such ostensible right, even by way of retrospective effect, if so chooses in public interest. 2002 9 SSC 634, the claim of the seniority of the employee is always determined the claim of the seniority of an employee is always determined in any particular grade or cadre, and it is not the law that seniority in one grade or cadre should be dependent on the seniority in another grade or cadre. Then ratio, Lordship. I'm submitting this ratio in the light of the submission, the judgments placed by my learned friend the other day.
Okay.
2015 11 SSC 12. It is well settled that the ratio of any decision must be understood in the background of that case. Each case depends on its own facts, and a close similarity between one case and another is not enough, because even a single significant detail may alter the entire aspect to decide. Therefore, on which side of the line a case falls is broad resemblance to another is not at all decisive. Because my learned friend has relied upon two important judgments. If I remember correctly, a Supreme Court judgment from Assam and a judgment from Arunachal Pradesh, where I should be, it talks about different cadre and bottom of the seniority list. In fact, that police case relates to special recruitment and normal recruitment in the police department in Assam. And the case from Arunachal regards to appointment promotion in the school department.
Legal principles may be laid down, but facts is.
Facts, my lord.
Yes.
Facts, because
We have to differentiate.
facts has to be differentiated. That is my respectful submission I'm making,
Yes.
because on the facts of each case, because here the facts of the case is totally different from these two cases which has been strongly relied upon by my learned friend. That is why I'm raising the issue of ratio.
And who has placed this judgment, this Dr. Anula? Someone has relied on this. Must be petitioner.
It must be petitioner. It must be petitioners, not us. Lordship, since my learned friend respondent counsel for respondent number 1 and 2 has made an elaborate submission, I thought that it is not,
Yes.
it will not be
Because
necessary
your
to.
submission mainly will be dependent on their
Exactly,
address. one
exactly.
and
That's
two,
why I'm
because-
only covering few areas,
Which it is, he has not covered.
yes, which he has not covered, only supplementing him.
Supplementing.
Much obliged, Lordship.
Hopefully tomorrow. we'll
I
finish
promised
it.
my friend that I'll leave sufficient time, so it's just 45 minutes I left. I am completing at 3:30, 3:25.
The problem is the roads, no? The-
Yes.
Everybody's pleadings is so bulky.
Yes.
Yes. This is separate, this is petitioner, this is respondent, no?
Then Lordship, tomorrow?
We'll continue tomorrow, keep it part third. Yeah, because Mr. Zimomo will reply. No? And let it be in the first.
If certain, if some order is passed, Lordship.
Just say part third, yeah. And let it be in the top of the list, hearing list.
Yes. Lordship.